gotten. Great, so it is now 10:30 a.m. here in Sacramento, California, and it is time for us to commence our first January 2025 California Law Revision Commission meeting. My name is Xochitl Carrion. I am your chair this year. It is a pleasure and an honor to serve as chair again of this commission and to lend my 16 years of experience in civil, criminal, and corporate law to this commission, and also to add to the diversity of this commission as an out queer Latina. Today, I want to give some time to thank all the folks here that are in person, as well as the commissioners who are on Zoom. We want to also acknowledge that some of our commissioners and some of our public members have been affected by the devastating and ongoing Southern California fires. And we send all of our prayers and blessings to all of those affected. And we thank the people that have been the first responders and all individuals and community members and political and civic community leaders that have come and really stood up and fought for the well-being of the Southern California population. Our hearts go out to them, and we want to acknowledge what is happening and let you know that you are in our thoughts, and you, while not present, are a community that is incredibly essential and important to this commission. And we look forward to receiving public comment to you in whatever way that we can reasonably accommodate. And a shout out to Commissioner Jenkins, who is in the front lines in the legislature, doing a lot of amazing work. And that's why she's not here right now in person, because she may be coming in and out because she's doing the hard work of making sure that our communities are safe in Southern California, as well as in California, as you've been doing so far. Now, I know that this is the beginning of the year, so I was hoping to make some brief opening remarks to let folks know about what this commission does.
Would you like to call the roll first?
Yes, thank you so much. Let's call the roll. Thank you.
No problem. Okay, so let's call the roll and establish a quorum. It looks like we have it. Commissioner B.
Present.
Senator Blakespear has indicated that she will be able to participate in at least parts of the meeting. I do not see her here yet. Commissioner Carrillo.
Present.
Commissioner Carrion.
Here.
Commissioner Kubas indicated that she is actually impacted by the wildfires and was unable to make it today. Commissioner Hebner.
Present.
Commissioner Jenkins.
Here.
Assemblymember Calra also indicated that he will be able to participate in parts of the meeting, but I see he is not here yet. Commissioner King.
I'm here.
And Commissioner Simpson.
Here.
Thank you. Okay, quorum has been established.
Thank you so much. And of course, this is our amazing executive director, Sharon Riley. So the commission is a nonpartisan agency that has been charged with looking at the California laws on behalf of the legislature. Our role is to intensively study complex and sometimes controversial issues, legal issues and legal ordinances, regulations, statutes, all of the different California rules. It's really important that folks understand that our scope is not to serve as an advocate for any side. Our scope is really to assist the legislatures in performing their duties in representing their constituents. So for us, it's incredibly important to have community involvement and public comment. Another thing we really look at is identifying major policy issues and questions for the legislative attention. We look to see at what isn't working in the law right now. That is really goes into our having experts. We have leaders in subject matter issues. We have civic leaders. We have community organization leaders. All interested people are part of this very large process of identifying what those questions are. And that is incredibly important for us in gathering the views of interested parties and interested organizations, governmental agencies, and businesses. Now, we also assist in drafting legislative language for the legislature to consider and adopt. And that is one of the other steps where we have a very experienced board here of commissioners that lend their talents and their expertise in doing so. If you'd like to get to know a little bit more about us, we have all of our websites on the
clrc.ca.gov.
Thank you. Thank you so much. So what we need to do here is to help the legislature accomplish needed reforms that may have not been able to be accomplished due to the heavy demands of the legislature. Today, we have a very full agenda, and we will have a very full agenda for this ongoing year. It's very exciting to be able to address these legal issues that have direct impact on Californians. And right now, the 4 studies that we will be addressing today are the state and local agency access to consumer information from communication services. The second is the Equal Rights Amendment. The third is California antitrust laws. And the fourth is terminology relating to persons with disability. Now, as I mentioned before, robust public comment is vital to what we do. We cannot perform our jobs properly if we don't have interested parties involved and here. And we are very thankful of all the time that each person and each agency and organization has given to provide those public comments. Now, we welcome written comments at any time during the study, as well as throughout the agenda. Every agenda item will have a section in which the public will be able to provide comments on that particular item. Now, all of the comments will be on public record. These proceedings or commission meeting is public record and is being recorded and available. We also do accommodate for American Sign Language, which will come, we'll have a person here to assist with those translation, and we will accommodate other needs as presented to us. So please, if you need an accommodation, we will reasonably try to accommodate you. Please let us know. The only way really to public comment is to email our executive director and to make public comment here or to mail us information. Please do not individually contact any of the commissioners, including myself, Chair, and our amazing Vice Chair Simpson. We would love to talk to you, but it's vital that this commission continues being transparent and accountable to all Californians. And in order to do so, we need to make sure that all of these public comments are part of the record. Now, with that, I'll go and start with our first item, which is our minutes. Now, we have the minutes, which is item 1 in our agenda, and that's the minutes of our last meeting that took place on October 10th, 2024. It is memorandum 2025-1 as well as -2 for November 13th, 2024. At this time, I will ask if there is any public comment. Again, I do want to stress all of these information, all the drafts and memos are readily available at our website. If you have any issue at accessing those documents, please contact our executive director and we will promptly resolve that for you. Is there public comment at this time?
I see no hands raised.
In order to continue forward, we need a motion from our commissioners. Do I hear a motion to adopt the October 10th, 2024 minutes as well as the November 13th, 2024?
So moved.
In a second.
Second. Great. So I heard first Commissioner Carrillo and then Commissioner Yes, Simpson. Okay, just making sure. I was like, it was you, right? Okay. Thank you, Commissioner B though.
So I'll go ahead and call the roll then.
Great.
Commissioner B,
Aye.
I'm only gonna call those currently present. Commissioner Creo,
Aye.
Commissioner Carrion,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Commissioner King,
Aye.
Commissioner Simpson.
Aye.
Thank you. The motion passes. Now moving on to the second agenda item, administrative matters. We'll start off with our report of our executive director.
Sure. So I'm happy to report that this semester, we have 3 externs from the UCFS School of Law, 2 of whom are present in the room. And I'm gonna ask you just to step up to the podium so everyone can see you and introduce yourselves. And then I believe we also have somebody via Zoom.
Perfect. Hi, I'm Wu Chang. I'm a 2L at UC Law. The externing with the CLRC this semester. Happy to see the book.
Thank you for your contributions and your time.
Hi, yeah.
Please step to the podium. Thank you.
Oh, good morning, everyone. My
Yes.
name is Gregory Mabra. I'm a 3L at University of California School of Law, San Francisco. It's a pleasure to be here. It's a pleasure to meet all you guys, and I'm excited to work with every single one of you guys.
We appreciate your time
Well,
and your
thank you.
contributions.
Thank you, of course.
Hi, I'm Ryan, same school, same everything. I love government work. I love the government. I am very honored to have the opportunity to contribute in any way I can, and I look forward to working more with this commission. Thank you.
Thank you. Civil service is a calling and it's great to see you guys answering that call.
So we've already tasked them with projects and the work is underway and we look forward to hearing from them at future meetings. The next thing I wanted to mention is the budget update. So far, the Law Revision Commission has not experienced a budget cut. We continue to monitor that. Our budget for 24-25 and the January governor's budget is intact. So we will keep you up to date on that. Also wanted to give a brief update on hiring. But before I do that, as you know, we're down 2 people and I really want to give a shout out to Sarah, Megan, and Steve, who have just really stepped up to the plate to keep things going. So without them, we couldn't be doing what we're doing. We do have, as you know, Deborah Larrabee, our long-term chief of administration, has retired. We have interviews scheduled for next week. So we're hoping within the next few weeks, we will have somebody for that position. We also have an attorney 3 vacancy that was created when Sarah became the chief deputy. We're hoping we have applications and we're hoping to get to that in the next couple of weeks. So hopefully soon, we'll have some news to share on that. We continue to be interested in acquiring office space while we continue to monitor the budget situation. So we will keep you apprised of that. And also when having more administrative staff is going to help with things like that because those things are very time intensive. For last year, we had looked at the handbook for some specific updates. And as we were going through it, we realized that more could be done, but it wasn't, the timing wasn't quite right. So that's been an ongoing project and we're hoping we might be able to have that ready for the next meeting for your consideration. We just want to make sure everything's up to date with current law and current practices and always appreciate commissioner feedback on that. Internally, we've been updating our internal policies and procedures, documenting what our procedures are and things like that. That's been an ongoing project that will be continuing this year. Another thing that we would like to look at is modernizing our website. Our website works great. It's very functional, but we, at least at this point, think it probably could use a little modernizing. And if the commissioners have any suggestions about that, please let us know and we'll keep you up to date on that. And then speaking of modernizing, we did have the annual report on the agenda for this meeting, but we moved it to the next meeting because as we were going through it, realized it was kind of pro forma from year to year, and it was in need of updating. So we wanted to spend a little more time on it before we got it to the commission. So that's my report. Any questions?
I see no questions, so we'll move on to the next item under administrative matters, which is commissioner suggestions. Do we have any commissioner suggestions?
Can I go?
You have the floor, Commissioner Carrillo.
Thank you, Madam Chair. I was going to raise the issue of venue for our meetings, but in discussing it with Sharon, it sounds like the current venue is temporary while Cal EPA is under construction. So I don't think we need a long discussion about it. My point was mainly going to be that the location chosen for this meeting isn't super convenient. About half the commissioners, couldn't make it there. So if we're going to be venued in downtown San Francisco, downtown Sacramento, that, for the foreseeable future, that would be my preference. If you need locations outside of that, if you're looking for locations in Berkeley or San Francisco, for example, I'm sure one of the law schools would be happy to provide an auditorium.
Do we have any comment to that? I see Commissioner Jenkins.
Yes, I just wanted to add that we have renovated a portion of our office space that will be available in March. So that could be an option to look at as well.
Thank you. Are there any comments to Commissioner Carrillo's initial suggestion? Thank you for that suggestion. I think that's something that Sharon here will be looking into, and we will be following up and giving an update to any venue changes or venue opportunities. That also to the public, if you have a venue that you think might be a good use of us, we have to ensure that there's good tech. So that way we can keep these recorded, make sure that all the public is informed and has accessibility. The public must have physical and I guess technical accessibility to these meetings. So thank you so much. Now, moving on to the next item under administrative matters, that is for open government laws.
And that will be presented by Steve Cohen, who is attending remotely due to a family emergency.
Good morning, commissioners, and apologies for not being a person at the meeting. This memorandum is an annual memorandum we present at the beginning of each year. It summarizes all the relevant provisions relating to open meetings that apply to the commission. It's purely informational unless there's been reporting of some new and relevant legal developments over the course of the past year that might cause the commission to need to consider making some new decision about what it wants to do. We haven't reported any new legal developments this year. So much of the content of the memo is carried over from the previous year, and it's presented primarily as a refresher for commissioners, both continuing and new commissioners. Very minor matter in reviewing the memo in preparation for the meeting. I did notice a miscite in a footnote, and just for the record, footnote 80 should refer to Government Code Section 11123.5G rather than 11123.2G. But other than that, I'm happy to take any questions that anyone has about anything in the memorandum or requests for any changes or additions to the memorandum that we can bring to the commission in future meetings.
So I'd like to just add one thing. The authority that we have to meet in this fashion today, that the commission has to meet in this fashion, today is actually set to expire at the end of this year. Our understanding is that there very likely will be legislation to extend that sunset. As we can see today, several commissioners needed to take advantage of that opportunity to meet in this hybrid fashion. So it's something that we'll be closely monitoring and keeping the commission up to date on. And then back to questions.
Yes.
Sorry, Steve.
No
Thank
problem.
you, Steve. Do we have any questions regarding this memorandum from the commissioners? Or comments? Seeing none, I will ask if there is public comment at this time.
There is not.
We do not need a vote as this is an informational memorandum for everyone. It's a summary as Steve just told us. And Steve, I just want to say well wishes to you and your family. And thank you for your work on this.
Thank you.
Now we'll move on to the final item underneath administrative items, which is our 2024 to 2025 annual report.
Which we moved to the next meeting.
We've moved to the next meeting. So that concludes item number 2. So I will ask in general, is there public comment regarding item 2 administrative matters at this time?
Seeing none.
Okay, we see none in person. We also see none. We have a queue of people that have joined us in Zoom. While the audience and the public may not see who's on that, our wonderful staff here is managing that and is very attentive to those needs. So let's move on now to our third item, which is 2025 legislative program.
So this is a memo that the staff presents every year. It's a little bit unusual this year in that we do not have any final recommendations. And so the staff will not be seeking to introduce legislation effectuating the commission recommendation by the February 21st, 2025 bill introduction deadline. Of note, the commission did issue a final report on landlord-tenant terminology in December 2024. However, the commission did not make recommended changes to existing law, so there was nothing to, the report was final and didn't need further work. We do have 2 studies on the agenda today, Equal Rights Amendment and the state and local agency access to customer information from communication service providers. That's a mouthful. Depending on the commission's decisions, they could result in final reports that include recommendations for the legislature. And I see that I have in 28. Yes, the final recommendations would be likely made in 2025. And so far, we've had 2 legislative offices who have expressed carrying legislation enacting the final recommendations from those studies in 2026.
Great, thank you. Are there any public comment or are there any questions or comments from commissioners regarding this item?
Quick question for.
Please.
Sure.
Has there been any legislative feedback on the landlord terminology recommendation? Did we hear first meeting?
We have not heard anything. I don't know if Steve is still on. I'm sure he would have made me aware if we
yeah.
had, but no. We did distribute it. We sent it
Yeah.
to the Secretary of the Senate, to the Legislative Council, to the Assembly, to the Governor's Office, to the Judiciary Committee, so it's been widely circulated.
I received no comment individually either.
Yeah, I'm just curious.
Thank you, Steve. Is there public comment on this item?
No.
I see no in person and there is no public comment virtually. Now, moving on, our next item is actually a special order item. What that means is that we have given public notice that this item will be heard at 10:30.
11:30.
Excuse me, 11:30, thank you. No, keep doing that,
Okay.
please. Please. It is now 10:54 according to my computer. So what I would propose, unless there is an objection from any of the commissioners or the public, that we move forward to item 5. Do I hear any objection from the commissioners? Is there any public comment on this particular issue now that I've raised it? I see no in person and none virtually. Great. So let's go ahead and move on. We are going to run a tight ship because we have a lot of work to do here. So we're going to keep on moving. State and local agency access to consumer information from communication service providers, and we have our wonderful staff member here to present on that. You can introduce yourself too.
Good morning, Commissioners. I'm Sarah Huckle, Chief Deputy Director, and I'll be presenting Memorandum 2025-8. And this is related to the notice of subpoena. This memo presents updated legislative language based on additional stakeholder feedback from the Department of Justice and the Electronic Frontier Foundation. The major changes are reverting the requirement to deliver notice to the government entity and adding a provision requiring a service provider to deliver notice if the government entity is unable to do so. Otherwise, all of the other changes are noted in the memo. Does the commission have any questions or comments?
Yeah, could you, there was DOJ's concerns about one of the matters, too broad a definition of electronic communications. Could you just kind of talk me through that a little bit? Sure, I understood.
In conversations with them, they were looking to narrow that definition somewhat, and they were concerned about the idea of mass communications having less of an inherent privacy interest. But we were unable to narrow that to a definition that was acceptable. Also, it was the intent in prior memorandums to keep this set of laws close to California Electronic Communications Privacy Act that exists in the Penal Code for criminal provisions, and we borrowed this definition directly from that.
So, and the implication in terms of state and local agency access to communication is what they were suggesting, the less information available to agencies or more? I wasn't sure what the implication of
Their request was to not require as much procedural notice to consumers when acquiring information.
Okay.
So this would be more protective of consumers, this proposal.
Okay, got it. Okay, that was, thank you, that's helpful.
I see that Commissioner B has a question or comment.
Thank you. Question, in some of the prior reports, the title was administrative subpoenas. And now I know we're just calling them subpoenas, and I'm wondering if there's some significance to that change?
Yes, in conversations with stakeholders, this was subpoenas broadly, and this is fairly interesting because I have not practiced in this area before. The administrative subpoena includes pre-trial investigations. And we relocated this provision to the area closer to the consumer, the prior law regarding the access to consumer financial protection records, which was the original model for this law. There was a request from stakeholders that we avoid the pre-trial investigative subpoenas because that was a process that in their minds was working quite well and would be more difficult to change. So this still requires notice of subpoena in ongoing cases where it is already before court when actions have been filed.
As a trial attorney, I would agree with that sentiment.
Okay, good.
Yes.
Thank you.
Madam Chair, would you entertain a motion?
There is no motion needed for this. if I recall.
Sure, I just want to clarify that at this point, if the commission is comfortable with the language, does the commission want to approve the language for tentative recommendation to be considered at the next meeting?
So what we can do, is there any objections? We can do it the opposite way, or does anyone have any concerns that they'd like to raise? In this scenario, for the public's benefit, there are times where a formal motion is needed, and there are times when it is not needed. When it is simply to give direction to staff and not make a substantive decision on how we're gonna move in the direction of a study or move in the direction of language that we are proposing or recommendations, that is when we need a formal vote. So at this time, that is the reason why we are not calling a vote. Given what I've just said, commissioners, is there any opposition to the direction that staff has proposed? I see none, so please continue your great work. Thank you very much. Now, any other public comment here? Do we have virtual or in person? I see no virtual. I literally do not see physical, so we will move on.
Great.
Thank you so much.
Now I will be presenting memorandum 2025-9, and this is related to the Equal Rights Amendment. Just as a bit of current events backstory, on January 17th, you may recall then President Joe Biden declared he considers the ERA to be the law of the land. However, that did nothing to quell the multiple legal uncertainties around its formal adoption and has no impact on this study. Also, as you'll recall, this study was divided into two parts: drafting a sex equity provision and fixing current laws with discriminatory language or disparate impacts. The first part of this memo presents a revised sex equity provision based on the Commission's feedback and discussions with the ACLU of Southern California, National Women's Law Center, and Planned Parenthood Federation of America. The second part of the memo presents for consideration stakeholder ideas for addressing California laws with disparate impact. But for various reasons noted in the memo, the staff recommends that the Commission do not take action at this time on that portion. Does the Commission have any questions or comments?
And I would like to note, this is again a situation where staff is requesting direction and not necessarily a formal vote. Given that, does any commissioner have any comments or questions? Vice Chair?
Not on the specifics of the language. I was thinking about what you said about former President Biden, making that sort of statement. What might it take to have the ERA become officially part of the Constitution? Does it have to be a new amendment ratified by 3/4 of the states? Does it have to be, a court
That would
decision
help.
about those states who allegedly withdrew their
Commissioner Carrillo, did you want to take this one or shall I give it a shot?
oh yeah.
I was just kibitzing.
You are an
it-
expert on this.
If I could read your mind, I think you were about to say that the archivist would have to publish it, which was one of the things President Biden did not say, or Commissioner Simpson's suggestion that 3/4 of the states could ratify it. That would also help.
And there's also a concern that 3/4 of the states who did ratify it, several of them did so after the deadline, which may or may not have been
Yeah.
important. And
Some of them
several
have since rescinded it.
have rescinded.
Right.
And so it's still an untested question as to whether one can rescind
Right.
an approval,
Right.
or whether the Congress could put a deadline on it in the first place.
Right. Also an open question.
But the good news is in the course of this study, we found that California's laws are very robust. And we did get feedback from national organizations who believe that our reinforcing our laws will prove to be a national model and help other states in this area as well.
Now, there may be some concerns from different communities such as the LGBTQ plus community and recent federal implications, how would that impact this particular study, and does it impact it at all?
I don't think it necessarily changes California's law, and part of the exploration of the current laws was that California's protections are fairly robust to include, when we define sex, it was quite expansive, so it should cover all populations.
Thank you. Do we have additional questions or comments from the commissioners? I see none. Do we have any public comment on this issue? There's none virtually, and I see none in person. So thank you so much.
And again, this is for a non-objection for purposes of a tentative recommendation to be considered for the next meeting.
That's correct. I heard no objection from any of the commissioners. If there is an objection, this is the time. All right, the time has now passed.
Great. Thank you so much.
Thank you. All right, we are gonna now move on to item number 7, which is terminology relating to persons with disability. And it's the introduction of the study. And we have Steve that will be presenting on that again. Thank you, Steve.
Yes, thank you. So this memorandum introduces a new study that was assigned to the commission by the legislature last year. It charges the commission with evaluating and recommending non-substantive revision of multiple references in all the existing codes to the terms dependent person and dependent adult in order, as indicated in their assignment, to describe these persons in a respectful way, while still preserving their legal rights, and potentially make them more accurate in that, for example, many persons who meet the current definition of dependent adult or person can and do live independently. The assignment specifically directs the commission to form and engage in this study with a working group consisting of many different participants, and a couple are specifically identified in the charge. But certainly any suggestions by any commissioner would be very much welcomed. That's how the staff proposes to start work on the study, is to first form the working group and then start to come up with a game plan for how we could best fulfill the assignment. We've already received one public comment in an email that I received with some suggestions. The two entities that are identified in the charge are the State Department of Social Services and the nonprofit organization that actually represents the persons with disabilities here in the state of California that have been charged through a special federal program. That's an organization called Disability Rights California. Other than that, the staff is looking for suggestions about that, and then the staff is looking for any further comments or direction that the commission might want to offer in terms of how we proceed with the study. And I welcome input.
Now, you raised 3 questions in your memorandum. Again, these questions are seeking staff guidance and not a formal vote. That being whether the scope and objectives as presented in the memorandum and by Steve here today are, if there's any questions or concerns, and if there's commission is agreeable to commencing that study. One of the key issues I think that you also raised is whether there should be additional working groups beyond those entities and persons already identified in the section applicable. And my perspective is that we should include as many people as possible in providing their expertise, especially as this impacts so many of our community here in California.
I certainly agree. And all I would say is that having done this quite some time ago when the commission studied a revision of mechanics lien law, at some point there can be so many voices that it's impossible to get anything done. But certainly we want to be as inclusive as possible. And, we'll come back to the commission and talk to the commission if there's a problem with too many people being in this working group with people disagreeing. I have a little bit of experience in this area, and it's certainly my sense that they're very strong opinions, and language is very important in some respects. And we want to be able to get something done, but absolutely we should, in the beginning, we should be as inclusive as possible, certainly in terms of forming the working group and having as many participants as possible.
Are there any comments, Commissioner King?
Yeah, I think this is great that the commission is tackling this as the head disabilities attorney for the CSU system for many years, and there's a great need to redefine terms for dignity and for accuracy. I just want to point out that I didn't see in the materials in reference to the conservatorship community. It seems to be a natural, very interested stakeholder in these issues, besides the disability nonprofits and disability advocates that you had earlier mentioned. So we should reach out to those people because our population is aging considerably, and conservatorship and the baby boomer generation, whether or not they'll be considered to be dependent or not adults, is going to be a primary issue for the near future.
All right.
Thank you. Are there any additional comments, Vice Chair?
Yeah, just a question. I mean, as I was reading, I mean, I think your approach, Steve, is right on the money. My question is, this sounds kind of a lot like our landlord tenant study we just, went through. And in that one, there were those terms had fairly large different definitions throughout different parts of the code. And I was just curious as to, are we likely to face a similar kind of issue here with dependent adult, dependent person? Or is this more, can we find terminology to apply, in those definitions that make me more comfortable and more appropriate kind of terminology?
I think that we will have a much better shot here with this study. I think there's a much greater likelihood of what I think we could call success. First of all, there are a lot fewer references to dependent person or dependent adult in all the codes than there were to landlord, tenant, and other related terms. The other problem was in the other study, those terms were often used with no applicable definition at all. And so in order to standardize the terms, we first had to try to figure out what those terms might have been intended to mean. Here, we don't have that problem nearly as much. There's really not a definitional issue as far as I can see, there, at least right now. There might be in some instances, but the problem is really just changing the term of dependent adult or dependent person to something else, which is more respectful and more accurate and more preserving of rights, et cetera. So I'm maybe somebody will have an alternative approach to go at it. There's a finite number of choices, I'm sure. And, it seems to me that we are likely to be able to come up with something which is going to work, I would think.
Thank you. Thank you.
Any additional commissioner questions or comments?
Actually, can I ask a
Okay.
question? Can I?
Yes.
Thank you. Commissioner King, did you have any specific organization in mind?
Not right this minute, but I do have a friend who's a major leader in the conservatorship community, and I'll forward his name and contact information to you. Furthermore, I think we met some people when we did that massive review on trusted estates issues about 2 years back. And as you know, there's that group, I forgot their name with the acronym, that came to every meeting to help us with that. And
Yeah.
so I would think lawyers in the trusted estates field would be conversant with who works on conservatorship issues.
Excellent. Thank you. So I guess I don't think a vote is required here. Again, we've asked for questions and it appears that the commission is fine with how we're proposing to start the study. And if any commissioner thinks of any other participant they think would be a good participant for the working group, just please forward it along. I mean, we want to be, as I said, as inclusive as possible to get started.
Get yourself a thesaurus.
I've already been looking actually, but we'll see.
So hearing no commissioner objections, is there public comment?
There are no public comments.
Okay, there's no in-person or virtual public comment. So we will now move forward. Now, it looks like we have hit the 11:15 mark, which is the great time for us to take a 15-minute break. We will reconvene promptly at 11:30. Please feel free for those that are on virtually to sign up a little bit before the 11:30, so we make sure everything is nice and tidy and we make sure all the tech works. And we will be back here at 11:30 a.m. Thank you so much.
So Sarah, it looks like our ASL translator is on.
All right, thank you everyone for coming back. We are reconvening today's California Law Revision Commission meeting. We are going back now to item 4, special order, which is the recodification of toxic substances statutes. I also want to acknowledge that we have an American Sign Language translator virtually. Thank you so much for your services and we appreciate you being here. If there, as I mentioned before, if there are different additional needs for interpretation of any different languages, please contact staff and we will reasonably accommodate. We can move forward and the presentation will be made by our, there we go, great, Steve, thank you.
All right.
You moved in our screen, Steve, I was looking for you.
I
I
didn't do
see also
anything.
Commissioner Jenkins, raise her hand.
Yes, I'm sorry. I just wanted to acknowledge that Assemblymember Calra has joined us for this portion.
Thank you so much. I appreciate that. Welcome.
All right. So before I begin, I wanted to ask, while I'm making my presentation, it's hard for me to see the translator. And I want to make sure that I'm not speaking too quickly or not causing any problem. Is there some way we can have some signal of some kind if that happens? Because in the past, I just sort of blaze on through and it's hard for me to tell if there's been a problem, and it would be particularly difficult with the participating via video for myself. I don't know. I would just ask for any suggestion.
So if our translator could indicate if Steve is talking too fast, or staff can also monitor that and we'll flag it for you, Steve.
All right. All right, thank you. So the first of 2 memoranda that you have on this study, toxic substances, is memorandum 2025-6, which is a cumulative draft. Just in brief summary, as the commission is aware, we have been working for some time on an assignment from the legislature to recodify 2 very, very lengthy chapters of the Health and Safety Code dealing with toxic substances. Some time ago, the commission submitted 2 final recommendations and the legislature enacted a recodification of the shorter of the 2 chapters. And now we are a little ways into recodification of the longer of the 2 chapters. The process we've been following in this recodification of the 2nd chapter, in part because of how long it is that at each commission meeting, the staff presents proposed recodification of a portion of that chapter, a relatively small portion of that chapter, the chapter in the existing Health and Safety Code. We present that to the commission for proposed recodification. We seek approval to include the proposed recodified provisions in what will eventually be a draft tentative recommendation, recodifying the entire chapter. And because we're still a long way from completing that draft tentative recommendation, each time the commission approves a batch of new provisions, we take that and we put that into a cumulative draft, which is an ongoing draft, which we update each time. And that's what you have here for this presented by this first memorandum. Generally speaking, the cumulative draft doesn't raise any questions. or raise any issues, because essentially it's just it's just the previous cumulative draft with the newly recodified approved provisions added into the cumulative draft. So it's presented primarily as a reference for commissioners and for members of the public who want to monitor how we're doing and see how the recodification is being built over time. And it may be that there will be changes over time that will have to come back to the commission relating to organization or perhaps some other things. So this presented cumulative draft is the same as the one that was presented to the commission at the last meeting, except including the batch of newly approved recodified provisions that the commission said were okay to add into a draft tentative recommendation. Finally, unless the presenting memorandum for the cumulative draft points something out that needs to be considered by the commission, there's really nothing to talk about. There's no new issues, there's no decisions, etc. Occasionally, though, there will be something, and that is the case here. It's a small point, but as indicated in the presenting memorandum, when the staff was taking the last batch of approved recodified provisions and putting them into the cumulative draft and reviewing again how it would fit, etc., the staff noted the use of a term, there was some language in the batch of approved provisions that the staff thought could benefit from some public comment. We seek public comment by including what are called staff notes after the proposed recodification, something along the lines of, this provision seems to be vague. Could somebody help us basically with what this particular word is intended to mean? It could be any number of things, and you've seen a number of these staff notes. We didn't have a staff note in the last batch of recodified provisions, but I prepared some to put in the cumulative draft if the commission approves. They're on page 110 of the draft. They're shaded in gray. They simply just ask for if anyone a public comment on clarifying the use of some language, which was in the section. I'll give everyone a second to go look at it or go find it. And then that is something that I would ask for a vote on, because this is something we're going to take the cumulative draft, and eventually this is going to be the proposed legislation part of the tentative recommendation. So we want to be able to say to you that you've already provisionally approved everything that's in here.
Do we have any questions or comments or suggestions from commissioners?
Right. So certainly we want to ask, and I want to just point out that that will be one thing and possibly the only thing I'm going to ask for a roll call vote on. But certainly, if anyone has any questions or comments about any other aspect of the cumulative draft or the process in general, I'm happy to answer.
Seeing that there are no commissioner comments or questions or suggestions at this time, I'll ask if there's public comment on this item. There is no virtual or in-person comment at this item. Is there a motion to approve the requested approach of staff?
So moved. Second.
Great. Now, if we can call the, yes?
I'm sorry, I didn't the motion to approve. Approved adding the notes in the cumulative draft. Is that?
That's correct, yes.
Thank
Yes.
you. All right.
Which is, to be very clear, the memorandum has the specific questions for everyone that the staff is presenting. Of course, our commissioner members clearly review all of these things, so we may know these questions in advance. But the question here is, does the commission approve the inclusion of the proposed notes in the cumulative draft following proposed section 64160? There's a pending motion right now. There's been a first and second. Let's go ahead and move on to roll call.
Steve, would you like me to call roll? I don't know if you have a roll call sheet.
I Well, you can call it, it's easier. I do, but it's a little harder to see.
Sure,
There's
okay,
some screens that are not lit, so I can't see the larger group. That would be helpful if you could.
okay. I will call roll for everybody who's currently present. So Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Carrion,
Aye.
Commissioner Hebner,
Aye.
Commissioner Jenkins,
Aye.
Assemblymember Calra,
Aye.
Commissioner King,
Aye.
and Commissioner Simpson.
Aye.
All
The
right.
motion passes.
All right, thank you very much. And would you like me to move on to the next memorandum?
Yes, please, which is the recodification of the next portion underneath this item.
Yes. So as we just reviewed, this is a new batch of recodified toxic substance provisions for provisional approval in an eventual draft tentative recommendation. And a little bit more clarification here, has been staff's practice. When we present these proposed recodified provisions for the first time, we show changes from existing text with strikeout and underscore, except for, obvious changes in section numbers. There's certainly all the provisions are going to be renumbered. So we don't do this in the cumulative draft because if you approve these revisions, then we clean that up when it goes into the cumulative draft. But so since this is the first time you're seeing the proposed revision of these provisions, we're showing the strikeout and underscore. Because the study is non-substantive, we've been directed specifically by the legislature not to make any substantive changes to existing law. Most of the changes you would see are pretty much just organizational changes, moving things around a little bit, perhaps changing subdivisions to paragraphs, etc., things like that. Occasionally, there are attempts to clean up language in a way that would make the text of the section more understandable without changing any meaning. And again, as was referenced in the last discussion, when there are perhaps questions where we think public comment would be helpful about the meaning of a section or about the revision that we've proposed, we have staff notes in the proposed recodification underneath the proposed revision of the section and following a proposed commission comment. So I'm certainly not going to go through every one of these provisions, but I'm happy again to field any questions or comments about any revision or anything about the presentation, the memorandum. And then if there are none from the commissioners or the public, I would ask for another roll call vote to provisionally approve the contents of this draft to then be included in a draft tentative recommendation. And again, you will also see it next meeting in the cumulative draft that we present next meeting.
Are there any comments or questions from the commissioners on this topic? I see none.
Sorry.
Is there? Yes, there are. Great, thank you. Commissioner Jenkins.
Steve, you're not looking for formatting type of comments, right? You're just looking for overall.
Well, I guess, I mean, you would be ideal to obviously to talk about that or talk to me about that or talk to the staff about it. I don't know that we need to discuss that. We could certainly.
I've just seen a couple of things that I think, when it eventually comes to our office for drafting, we would likely make some changes, some suggested changes, but I don't think it's necessary to go through them all here today.
That's fine, and perhaps we can develop some process by which we sort of do that offline. I don't know. We'll have to perhaps talk about that, but certainly that would be welcome.
Okay. Feel free to reach out.
Great. Any additional comments, questions from commissioners? Are they public comment on this issue?
No public comment.
Okay, there is no in-person or virtual public comment. Now, is there then a motion to provisionally approve the proposed legislation in the attached draft for inclusion in a future tentative recommendation.
Move approval. I'll
Right.
second.
Great. Can we please call the roll call?
Yes. And I again will call the names of the commissioners who are currently present. Commissioner B,
Aye.
Commissioner Carrillo,
Aye.
Commissioner Carrion,
Aye.
Commissioner Huebner,
Aye.
Commissioner Jenkins,
Aye.
Assemblymember Colra,
Aye.
Commissioner King,
Aye.
and Commissioner Simpson.
Aye.
The motion passes. Thank you for your work on this.
All right, thank you very much.
I also would like to note for the record that all of the commissioners that previously were on in the morning session prior to our break also are on in this after convening portion of the morning. So at this time, we will be taking a lunch break a little earlier than planned, but everyone have a great lunch. We will be back here for at 1:30 p.m. where we will
12:45.
Did we change that to?
Oh, I am so sorry. Yeah, I think
Okay,
we're ahead of schedule, so let's go
Great.
ahead. We can do 1 or 12:45.
if it's fine with the commissioners, I believe 12:45 would be best if give us more time. Unless there's any objection from commissioners or any present folks or the public, then we will be reconvening at 12:45. Thank you.
And
Great. We are currently still recording, correct? Good afternoon, everyone. Thank you for joining us here in our afternoon session of the California Law Revision Commission meeting today, January 23rd, 2025. Again, I am your chair and we have our amazing Vice Chair Simpson here. We are now going to go to our last item, which I think many individuals are interested in, that deals with our antitrust law study. Before we go and embark and just jump right into what the study is and the memorandum that has been prepared by our staff, I'd like to frame a little bit for the public and all folks present here and virtually, what is it that we're doing? So I'm gonna make some brief opening remarks and then we're gonna jump right to it. I also want to stress to folks that we will have an opportunity for public comment. And I will go ahead and do that. So prior to making those comments, I want to acknowledge that our commission members are here virtually and you can see them via our Zoom, and acknowledge also that we are here with Senate Member Catherine Blakespear. Thank you so much for being here in person. We know that you are incredibly busy and it means a lot that you have taken the time out of your incredibly I'm sure hectic schedule to be here and be part of this very vital and important conversation. All right, so how did this all start? In 2022 through ACR 95, the legislator tasked the commission to study the following issues. Those are three main issues. It is first, whether the law should be revised to outlaw monopolies by single companies as outlined by Section 2 of the Sherman Act as proposed in the New York State's 21st Century Antitrust Act. and in the Competition and Antitrust Law Enforcement Reform Act of 2021, which was introduced to the United States Senate, or as any outlawed in other jurisdictions. The second is whether the law should be revised in the context of technology companies so that the analysis of antitrust injury in that setting reflects competitive benefits such as innovation and permitting the personal freedom of individuals to start their own businesses and not solely rely whether such monopolies act to raise prices. The third is whether the law should be revised in any other fashion, such as approvals for mergers and acquisitions and any limitations of existing statutory exemptions to the state antitrust laws to promote and ensure the tangible and intangible benefits of free market competition for Californians. According to the authors of ACR 95, the Cartwright Act was written half a century before the idea of computer networks even existed and cannot possibly be expected to give government the tools it needs to ensure a fair and competitive modern marketplace. California's antitrust statutes are ripe for modernization, and the nonpartisan California Law Revision Commission, us, is the best body to, I mean, we could be the buddy of the legislature, right? But, right, we're there to support them, is the best body to advise the legislature on possible reform. Now, for the past 2 years, we've been working on this. The first year was largely devoted to educating commissioners about the complex areas of antitrust law. We were blessed to have so many incredible volunteers and legal experts and practitioners come and speak to us. And I want to stress to individuals that all of our sessions are recorded. Those presentations and materials are available to the public. It is the best free legal course on antitrust you will ever receive. So please feel free to go in there and, you know, do some homework. Now, the second year was focused on 8 reports prepared by expert working groups composed of leading antitrust academics and practitioners to examine various aspects of antitrust law. We've taken public comment at each of our meetings and received over 100 written communications, comments spanning thousands of pages from a wide variety of sources, including think tanks, universities, Chamber of Commerce's advocacy groups, legislatures, antitrust practitioners on both sides of the issue, and individual business owners. Now, here today, we're entering into our decision-making phase of the study. So what does that mean? That means today we are considering staff memorandum asking the commission for direction on steps in the study. The current memorandums that are presented are here for direction, not for substantive approvals. Therefore, it is unlikely that in this particular session that we will need a formal vote, but we will need to be able to approve any of the requests for staff for guidance and their approaches that they've suggested. Those memorandums are available to you online, and those questions of what the staff wants us to look like are available to you. Now, the staff memorandum is crafted within the framework of the questions posed by ACR 95. While the staff memorandum assists us in having this conversation and being able to really kind of delve into these issues and the nuances of how we can be practical in providing the necessary information for the legislature to make its decision. It's very early in its stage. The decision-making process will continue forward. Depending on the directions of the commission, the staff will provide additional memoranda for future meetings with further decision points and draft legislative language. As I previously noted in the beginning of this meeting and throughout this meeting, public comment is vital It is necessary for us to continue our work here in the study and the process, as well as to continue to receive oral and written public comment throughout the process. As I noted before, it is essential that you do not individually contact any of the commissioners, including myself, the chair, and our vice chair. All public comment should be provided to our executive director. This process is assisted by staff memorandum. It will result in a formal tentative recommendation, which will go out for official public comment, followed by a final recommendation that is presented to the legislature. This could happen as early as the end of this year, but depends on how the commission chooses to move forward. So this is why it's so important, and we are very grateful for all of the people here that are in person at the meeting, as well as those people that are here virtually to share those comments. If you want your voice to be heard, you need to speak, and we need you to be here, whether it's written or in person. So I encourage you, strongly encourage you, to please be part of this process and engage with us so that we can make the best informed decisions to move forward this study. Having said all of that,
Can I just make a small comment?
of course, please,
Okay,
Commissioner King.
I just want to clarify because I want to be, not create precedent here. I understand your admonition that people shouldn't approach individual commissioners and I'm fine with that for this study, but that's not what the Brown Act says. The Brown Act allows for individual contact, so as long as we make sure that there's not a serial meeting or a hub and spoke meeting. And as I did with an earlier time when our former executive director said that no one should be contacting commissioners, I pointed out to him on a different study that we were appointed by the governor to be representatives of our communities because we know people who practice in these areas. And so, for example, in our mediation confidentiality study, our executive director at one point said, you shouldn't be talking to any lawyers about the future of mediation confidentiality. And I pointed out then, and I feel compelled to point out now, well, of course I should be in contact with those people because I'm here as a representative of the legal community, as a representative of the sector of the legal community I practice in, of my ethnicity, of my age, and so forth. So I don't want there to be a precedent that the general public cannot contact commissioners individually. Given the sensitivity of this study, I don't have a problem with us not having contact with other people. But in general, commissioners are always allowed to have contact with other people. It's just incumbent on the commissioner to make sure it's not a serial meeting or a hub and spoke meeting and so forth. And the best way to do that, should we have some sort of contact with the public or someone interested, we need to report that to the executive director. So that, for example, if some lobbyists were to approach me individually, and I'm here assuming it's not a serial meeting, but it turns out that that person's working his way down all the commissioners, then that's very problematic. But so again, for this study, I'm fine with people not approaching us, but in other studies, it'd be very worthwhile for people to approach us. For example, the disability studies we just discussed, it'd be great, when we go to a local bar association or are in the community, if people just give us their thoughts on what you call a dependent adult or what you don't call a dependent adult. So that's an important function, I think, of commissioners to reach out and be reachable by the public.
Thank you. Your comment is greatly appreciated, and it's very important. Again, this commission deals with nuanced issues, and this is a nuanced issue. Here in this situation, we have determined that the best way to proceed, given that this is can be a controversial and complex topic with divergent interests and different populations that are interested in different paths. And I think what you highlight is that sometimes commissioners are not aware of the work that that person contacting us is doing. And we want to ensure that we meet all of our duties and not create a situation that taints the transparency and the accountability that we have in this commission. As I mentioned before, public record is incredibly important when looking at such a large topic that reaches such a huge and wide diverse of constituents. So thank you for that, and I echo Commissioner King's comment regarding all of our other studies and what we're doing.
Chair, could I ask a question, please?
Yes.
So could you just repeat what exactly are the ground rules we're following regarding meetings for commissioners? And whether those different for me as an elected state senator or as a member of this body? I would just like to understand exactly what that is.
Yes, I believe that you are wearing two very big hats. And in your hat, as a member of the legislature, that people are entitled and should contact you directly. But when you sit here as a board member, I would caution as to during the breaks, whether people want to individually start going into the details of this, because they could be talking to other board members during breaks, and then it creates a problem underneath the Brown Act.
Do we have an attorney here?
Yeah, I'm an attorney. I
So-
lecture on the Brown Act from time to time.
But so I'd like to know, like, not what is it recommended, but like, what exactly are we doing? Are we disclosing to the executive director? Are we disclosing publicly who we meet with? What exactly are the rules that we're using here?
Well, I haven't researched it, but here are my personal views. This admonition that we're being told to minimize contact or actually have no contact with people, it's not a rule. It's just a voluntary sort of self-policing thing. It's not a rule at all, and that's why I want to make a comment to emphasize it's not a rule. The Brown Act assumes that us as members of a legislative body have the knowledge to not engage in a serial meeting. And so the problem here, to be more direct than our chair has been, it's not the problem that this is a complex subject. The problem is this is a subject that attracts very well-paid, very large numbers of lobbyists, and that they could be approaching commissioners from all directions with various agendas and pretending that they're not serial meetings, but they could send different lobbyists from the same firm or different firms to approach us, and it would essentially be a serial meeting because those people would report back to the same person who hired them. So there's no rule as to who you could talk to, and you as a legislator will wind up talking to more people than us. And you as a legislature will be approached by more lobbyists than us because most of us don't live in Sacramento where all the lobbyists are most of the time or spend much time here. So I understand you wanting clarity because it was kind of implied there was a rule. And what I'm saying is there was no rule and that you can do whatever you want. As you know, there are consequences for violating the Brown Act. So none of us should be talking to people knowing that there's a possibility of serial meetings between lobbyists. We have to police ourselves. And so you can talk to anybody you want as long as you are cautious and don't create a serial meeting situation. And again, not a rule, but as a protocol, I always tell the executive director with whom I spoke, so that she can inform me, oh my goodness, that lobbyist has called all 5 people or is trying to call all 5 people. And even though he's pretending not to be interested in a serial meeting, it kind of walks like a duck and quacks like a duck, so it's a serial meeting.
Chair.
I'm sorry.
may I
Actually, if
ask
you can
you-
hold on, not yet. If I have a follow-up question for Commissioner King. Can you, for the benefit of the public, define what a serial meeting is? Because people might not know.
Yeah, well, under the Brown Act, which was passed in the 1950s, because elected and appointed officials of legislative bodies would meet in secret and rig votes or just, share each other's opinions. And then going to the public meetings would be very perfunctory because they had already decided long before the public meeting what the vote would be. So they passed the Brown Act to make sure that a majority of the board never meets and discusses substantively an issue that's on the agenda or before the board. So that's what we have to be cautious about. And a serial meeting it doesn't look like a meeting because 3 or 4 of us aren't in the same room. But if you have an intermediary, a friend of ours or a lobbyist, talk to 3 or 4 of us at the same time or around the same time, there's a strong possibility that information about one viewpoint could be shared with another person and another person still. And at that point, it's basically the same thing as having a meeting where the 3 of us are in the same room because the intermediary has shared knowledge among us. And, telling them, oh, Victor seems to want to vote for this thing and mentioning it to you. and then mentioning it to you. And at that point, it was as good as having a meeting with the three of us agreeing that we all really like this proposition. So that's what a serial meeting is. And there's various types of serial meetings. You could have a daisy chain where one legislature talks to another legislature, talks to another legislature, or a hub and spoke, which is the other type of serial meeting that we consider about, where it's not in a pattern like that, but that all the information is going to some central point and coming back from that central point, and knowledge is being shared. We should be pretty ignorant of how each other wants to vote on something before the board, before the vote. We kind of know, we may have heard remarks at these public meetings, but I should never know for sure that you will vote this way or that way, because then at that point I could try to rig things or try to ask lobbyists to focus on you or whatnot. And so I think those are the purposes of the Brown Act.
Thank you.
Just a technical thing.
Really quick though,
Yeah.
do you have an additional follow-up questions?
No, thank you.
Okay, I just wanted to follow up. I believe that Commissioner Hubner had his hand first, and then we'll go to you. Commissioner Hubner, you have the floor.
The executive director last year prepared a very simple, very straightforward guidance on this topic. Sharon, if you haven't already, would you just share that with the senator?
Sure.
It's in one paragraph, explains this very clearly.
Yes,
What the rule is.
absolutely, we can do that, and it's actually in our open government memo that was presented earlier in the day. There is a section on open meetings, and basically the advice from staff is, use caution. I don't know if we use that word, but to avoid exactly the kind of situation that Commissioner King is talking about. Thank you.
And report contact on this topic to the staff, because they're the ones who keep the data that will show whether or not a serial meeting seems to be starting to form. And then they will caution all of us to have no more meetings on that subject.
Correct. Thank you.
Vice Chair?
Mine was just a technical comment, doesn't change the substance of what Victor was saying, but we're not subject to the Brown Act. That's for local governments. We're subject to Bagley-Keene, which is the state version.
Very good.
There we go.
And I'm not aware.
Different set of statutes, but with parallel intents.
Exactly.
Yes.
And parallel consequences.
They're entirely different.
But you're a member
They
under
are.
the Brown Act.
Well, no, I'm
No.
not. I was a member when I was a mayor, but it's entirely different.
Okay.
Anyway, we don't need to.
But our memo focuses
Yeah.
on the Bagley-Keene Act, because that's what this governing body is subject to.
I believe that we have a question regarding process from the public.
Samantha Corbin?
Thank you so much. Can you hear me?
Yes, thank you.
Excellent. Awesome. I'm Samantha Corbin here representing the Bay Area Council, an 80-year-old employer-sponsored public policy and advocacy organization whose mission is to keep the Bay Area region the best place in the world to live and work. The LA Biz Federation has also asked to be aligned on the record with my comments here today. Let me begin by stating categorically that the Bay Area Council supports effective antitrust laws. The basic
I'm gonna interrupt you very quickly because I believe we thought you had a question regarding.
Oh, no, I'm so sorry. No, I can wait. I was.
Okay, no problem. If it's regarding process, we, I think it would be most appropriate to deal with it now since we are talking about that. And for any in-person public comment, please come to the podium.
Sure.
And if you could wait, that would be great, but we are very excited that you're here and we thank you for your time and your patience, and we look forward to hearing your public comment when that opens up.
Hi,
Yes.
Dan Robbins. I'm the commissioner of a different commission, have been for 18 years, so I'm mindful of these things. What I did want to stress, though, is after hearing this, it was a little chilling. You know, the origin of all of public participation is the First Amendment. We don't want to violate the Bagley-Keene Act. We don't want to violate the First Amendment either. It does guarantee the right to petition, and at least in my commission and in the Uniform Law Commission, you know, we actively seek out all of this. And so I think it makes sense to, you know, keep Sharon in the loop, talking to Sharon is always a good idea. She's very sensible and thoughtful, so that makes a lot of sense to me, and I get Commissioner King's comments. But I just, at hearing this, it almost made me like step back, like, do I want to participate in this process? So I think just giving the public clarity about, I think I'm a little confused, and I just wanted to also reinforce, this comes from everyone's First Amendment right to petition the government. As Cheryl will tell you, that's actually an exception to the antitrust laws even, because it seemed to be so important. So those are my thoughts. But if it's, I don't know if it's appropriate to recirculate Sharon's earlier advice or something like that, just to make sure everybody's on the same page.
And when you mean Sharon's earlier advice, you're referring specifically to?
Was there
The paragraph in the open government. memo.
yeah, was
Oh,
there?
I see.
Yeah,
Yes,
that memorandum, that memorandum is something that we issue every year. It incorporated our memo that was specific to the issue of serial meetings and notifying the executive director if you do have contact with somebody, that was the recommended process. There is a link to that memo in the memo that's on the commission's agenda today. So it should be clear. If anybody has any questions, you can always give me a buzz. I'm happy to
Right.
discuss it.
Right. Apologies for my ignorance. I'm not a lobbyist. I'm commissioner from another commission and in-house lawyer somewhere who does compliance. And so antitrust compliance, though, not compliance with these other rules. So thank you.
and we appreciate you being here, and you've been here at different meetings. I want to let you know that we believe in the freedom of speech, and for that reason, we've created a mechanism that I think ensures that we don't in any way violate our duties, given the wide breadth of participants. So you've spoken every time you've been here. I hope to hear from you. You've spoken today, and I hope to hear from you later.
You
What did I
will.
say?
I'll
I
give-
had a
Give
feeling,
you some information, so.
not
hopefully
that
it'll be
chilled,
helpful.
huh? Not that chilled. All right, great. So any other process questions from the public? Do we have any on Q Virtual? I see none in person. So let's go on and let's jump in.
Okay. So we are going to discuss memorandum 2025-11. With me to my left, I have Cheryl Johnson, who is our antitrust expert consultant, who is available to answer those very difficult antitrust questions that maybe I'm not quite prepared to answer if they come up. As the chair stated in her opening remarks, this is sort of our initial request of the commission to give us marching orders, so to speak, on how to conduct this next phase of the study. The memorandum presents initial recommendations for the questions presented in ACR 95. And also, we would like to reference everybody to memorandum 2024-46, which was on our October agenda, and it basically tried to pull everything together in one memorandum, reflecting the expert reports, the public comments, everything that we were hearing about it. So it's important to keep that in mind when you're considering what the staff is asking today. And the recommendations are based on those sources. So and I'm not going to go into super detail, but please ask questions as you have them. I'm sure everybody's read the material, so I'll try to do this in an efficient way and as efficiently as possible. So the first question is a very threshold question. And keeping in mind that the nation's primary federal antitrust law, the Sherman Act, was adopted in 1890, and California's primary antitrust statute, the Cartwright Act, was adopted in 1907 and has seen few substantive updates over the intervening 117 years. It may be time to take a look. And I think that was the spirit of ACR 95. So the Cartwright Act does not generally reach single firm conduct. As a result, California must rely on federal law jurisprudence to manage single large companies' market conduct within its border. So getting to the very threshold question, which is, should California revisit its antitrust laws? And that's a decision that's before the commission today in terms of giving direction to the staff. The staff is recommending that we draft recommendations, revising California's antitrust laws in the spirit of ACR 94 and looking to protect competitive freedoms within California's borders. At the same time, we do point out that the commission should heed the caution of critics so as not to disrupt California's enviable economy and its innovative environment. That's sort of the very high level view of it. Much more detailed memoranda will follow if the commission decides to instruct the staff to go in this direction in subsequent memoranda. So the question right now, does the staff agree with the staff recommendation that California should revise its antitrust laws? And then we'll break out into what that means underneath that very threshold question. So it might be a good time right now to take questions of commissioners.
Great. Any questions?
Comment and question or just?
Yeah,
question?
both, of
Okay.
course.
Okay, great. Yes, thank you. So I just want to first thank staff for your work on this. There's a tremendous amount of work that has gone into this so far, and I know it's very complex. And I also want to thank my other commissioners. There are only a few of you who are on this and you've been working on this for a long time. And I want to thank the public who's participated in this as well, because this is a tremendously important topic. So I appreciate considering balancing the need for comprehensive antitrust laws while also maintaining our innovative environment here. The short answer to the first question is yes. I think California should revise its antitrust laws. So I think we're going to be going sequentially through the questions. But I'm also mindful of time and I want to make sure that I'm able to communicate some of the things that are important to me. So I'm just going to make one other brief comment that might be applied to a different question. So I think one of the things that I think is very important is the differences in different business sectors. So for example, one of the second largest business sector in the state of California is the life sciences industry. And sometimes that industry can rely on temporary market dominance to recoup the R&D investments that they have. And so what that means is that sometimes there is a just naturally high market concentration because of patent protections and things. So I know we're going to get to a big tech question, but I am concerned about how is it that we tailor the environment we have in California, which might be different from a different state with their antitrust laws, and also, of course, the federal government. So I'm just flagging that as something that's important to me. And I also think that this conversation is tremendously important, and I'm looking forward to the rest of the discussion and hearing the comments from my commissioners. Thank you.
Thank you. Additional commissioner comments, questions?
So are you looking for a motion on, yes, we should?
I will move it. I move, yes, we should.
Yeah, I mean, that's why.
And I would suggest that we move forward from draft to final so that we can make progress here. Like if there are questions we agree on that we can say, yes, let's move, this is just a draft, but then final, because final then could actually solicit public comments. And so we need to make sure we're moving forward. So I'll motion if you want one. Chair.
Great. A motion would be great. So just to clarify, your motion is that, yes, we should move forward with this study and that you are adding.
Pardon me, Chair?
Yes. Good afternoon, Assembly Member Asha Kalra, excuse me.
Hello.
Go ahead, the floor is yours.
Hello, everybody. Yeah, thank you so much. And I appreciate the comments from and the work being done by the commission staff, and the senators. comments. I think there's a similar sentiment. Certainly, when I talk to my colleagues in the assembly, there's a lot of interest in this space, understandably. But I think there's a general sense that that California needs to take leadership on this, not just for our own benefit, but nationally. And I really appreciate and support the recommendations that staff has put forth, all of them. And certainly the first question being posed as to whether we should go down this road. I think that whether this commission recommends it or not, my guess is the legislature, or at least some legislators, are going to proactively move forward. And I really think we all can benefit from the work of the continued work of this commission in guiding us as legislators, as you've already done on this issue and obviously so many others. And so there's no doubt that, especially given being kind of the center of innovation, that there are going to be questions that are going to be posed as we move forward as to how we go about it. But as to the baseline question as to whether we should, absolutely. And as I said, just in the interest of time, I actually really appreciate all the recommendations that have been put forth by the staff and support all of them, including this underlying first question being posed. Thank you.
Thank you. So we have a first motion. I just want to clarify, your motion is.
My motion is not getting into the life sciences point. My
Yeah.
motion is just answering this question, which is, should California revise its antitrust laws? Staff recommends yes, and the motion is to follow staff's recommendation and do that.
Wonderful. Is there a second?
Second.
Second from Vice Chair?
Second.
Thank you. Now we'll go ahead and move on to roll call.
Sure.
Actually, I'm gonna pause on this just to make sure that we don't have any public comment before we do the roll call. We do. Thank you. If we have an in-person comment, if you could come to the podium, please.
Great, thank you.
Please identify your name and organization for the record.
Yes, yes. So my name is Dan Robbins. I have something in common with a lot of you. I've been, it's been my privilege to serve as a commissioner on the California Commission for Uniform State Laws for about 18 years now, 5-time gubernatorial appointee, spent thousands of hours volunteering for that organization. In recognition of that, they elected me president of the National Uniform Law Commission in 2021. The Uniform Law Commission has an antitrust study committee. And the Uniform Law Commission, for those who don't know, it's created laws like the Uniform Commercial Code, the Uniform Trade Secrets Act, the Uniform Antitrust Act. It's the last one you may not have heard of, but I bet you've heard of the first two. We did a study in this area. You'll hear me talk later about the Pre-Merger Notification Act and give you an update. But I did want you to know that we didn't go forward in other areas because we got a lot of input from the DOJ, the FTC, the AG's offices, and lots of businesses, the US Chamber of Commerce, Cal Chamber, and others. And there was a lot of controversy. So the point I wanted to make is I don't object to moving forward and continuing the work. I did want to caution you, though. I've read the staff report. I think it's fairly radical. I think you should expect to have an enormous amount of controversy if you go down that path. So you just need to be ready for it. Typically people don't always get involved in Sacramento until they see a bill number, but then, the whole thing changes. So I just wanted to make you aware of that in our past experience. If I could shift my hat for just a second, I have a day job as the antitrust compliance officer in the Motion Picture Association. It's my job to look at the 100+ laws and all the places my members film and make sure they don't violate any of them, all the antitrust laws. And I wanted to second something that Senator Blakespear said. Believe it or not, the motion picture industry and the life sciences business have something in common. We both rely on intellectual property. We both have periods. You've probably seen the marketing where it's like the #1 movie in America is, and it's true, for some period of time. But, one of the challenges we've seen with some of these bills is that, there's no temporal limitation. So you have some type of significant market share for a couple of weeks, and in New York, you would have been a felon. Like, this is something we actually want in America. We want people to succeed, and then subsequently others come and they take their place. That's what competition's all about. So it's just something that's similar that struck a chord with me. And then just to illustrate my first point, and sorry, I should have brought like two different hats, but.
Well, I will let you know, I'm gonna ask you to only keep your comments to 5 minutes.
Okay,
And
I'm
that we have a
almost
very
done.
specific motion is.
Yes, okay,
just
just
wanna
to the last
highlight.
point, and I thought you'd appreciate this because we've been in other states, on the controversy point, 5 years in a row, the New York bill has failed. It's highly controversial. It's one we've been at, you've been study. Minnesota, 2 years in a row. Pennsylvania also failed. New Jersey failed. Bills that aren't in the staff memo also failed. 2023, Maryland failed. So I'm not saying don't do it. I'm just eyes wide open. So thank you. And sorry if it went over 5 minutes.
No.
And always glad, by the way, to take questions.
So Madam Chair, it looks like we have at least 4 people who want, 5 maybe, who want to make public comments. We'd like to remind the public commenters that the comments at this time are limited to the motion that's before the commission right now, which relates to should the commission make, this is the threshold question, should we be looking at revisions to antitrust law?
Great. So why don't we call up the first person in queue for our virtual public comment?
Ben Gollenbeck?
Hello, can you hear me?
Yes, we can.
Okay, thank you very much. Good afternoon. My name is Ben Gollenbeck. I'm the Executive Vice President at the California Chamber of Commerce. On behalf of the 14,000 businesses we represent, we thank the Commission for your work so far and the work on California's antitrust laws. We have submitted, obviously, numerous written comments and also provided live testimony over the last year. I do want to offer our views today on Memorandum 2025-11 and the staff's recommendations. And while the staff's recommendations are certainly comprehensive.
I'm sorry, I'm going to interrupt you very quickly. As we mentioned before, we have a specific question. Can you limit your comments as to whether you believe that the commission should move forward with this study? And we will have other opportunities for people to respond to the specific provisions and questions raised in the memorandum as we methodically go through it.
Okay, so you don't want me to comment on the substance of the recommendations?
Not at this time, because right now we have a pending motion that is very specific and that pending motion is about whether the commission should move forward in the study. There will be other opportunities for you to make substantive comments regarding the issues that are raised throughout the memorandum. And I believe Vice Chair has a
Yeah, I was just gonna
comment.
make a comment. I think the question that's before us now is, should we make any changes to California antitrust law? Period. And then we'll be going through the specific questions on single firm, on mergers and acquisitions, on tax. At the moment, the question before the body is, should we make any change? We recommend any changes in California law. If not, then we're done. If so, then we move forward through the specific things. So that's, I think what the chair is asking is in the view of you or who you represent, what your view is on that particular question. Should we make any changes to California antitrust law? If that helps.
Okay, I can comment on that and then I'll save other substantive comments for later on. So on that matter, then I'll summarize. I can be shorter and just say that no, we don't believe that the commission should be moving forward. We actually believe that that's the key shortcoming with the staff's recommendations, is that there's absolutely no present evidence demonstrating that California's antitrust laws are failing. The recommendations don't establish that California consumers are suffering from reduced competition, higher prices, or lessened innovation because of holes in California law. In fact, to the contrary, competition and innovation in California are thriving under California's current antitrust laws, as evidenced by increased employment, new entry in new innovative products, services, and technologies. And so we believe there's already a robust antitrust oversight at both the state and federal level, and there is no reason to move forward with the recommendations in the staff recommendations and move forward with the study. I'll save my other comments for later on in the hearing. Thank you.
Thank you so much. And
Is it
go ahead,
still on?
Vice Chair.
Are you still there?
He may be still there, but
Ben
he
is still.
Oh, okay, no,
Yes.
my question, it's kind of a general. When we've heard specific comments to us, like for example, on the single firm issue, which is, we're not voting on that right now, but it's been suggested that, well, California doesn't have a single firm law, but federal law does, and federal law is fine. And which raised the question with me of, well, okay, federal law has a multiple firm, just like California. Is the objection to a single firm law functionally saying we ought to just repeal the Cartwright Act and rely on federal law? I mean, is that functionally what your organization would like?
Can you hear me?
Yeah.
Yes, we can now.
Sorry, it's just funny with the raise
yeah.
hand, lower
I'm
hand.
a
So
low-tech guy myself.
yeah, no problem. Let me, and again, I've got more extensive comments which I can get into, but just sort of talking about, there's the recommendation, as you said, to adopt the new California standard for single firm conduct based on the quote unquote abusive dominance standard, which.
Well, that's a separate issue, but yeah. This abusive dominance is not necessarily the same as single firm.
Right, but that's what but it's the recommendation on single firm is being based on that standard in the staff recommendations.
No, I don't, that's not how I read it, but anyway, go ahead.
Okay. So, well, okay. That's certainly our reading, is that it's based on the abusive dominance standard, and from our perspective, that's sort of unrelated to any both sort of state or federal standard or any materials we've seen submitted to the commission so far in the process. That's sort of a standard that we've sort of never seen meaningfully interpreted or analyzed by a court in the United States, at least so far as that we're aware. And, from our perspective, the novelty of this legal term by itself will bring great uncertainty as to where the line is between lawful and unlawful business. Indeed, the single firm conduct working group that studied this issue expressly rejected the abusive dominance standard, which is sort of underpinning this single firm conduct recommendation because of its unavoidable ambiguity. And so we don't think that the commission should sort of do the same.
I don't read it the same way you do, but I appreciate your comment. Thank you.
Thank you.
Robert Harrell.
Hi, good afternoon. Can you all hear me okay?
Yes, thank you.
Thank you. Thank you, Madam Chair, Mr. Vice Chair, members of the commission. My name is Robert Harrell, and I'm the Executive Director of the Consumer Federation of California, an organization that has existed since 1960 to advance consumer rights and consumer protections in the state. Madam Chair, I'll be very brief. The answer to the threshold question for us is a painfully obvious yes. The commission must move forward and open up antitrust laws. We'll reserve the right to make additional comments later on, depending on the sub questions and issues. But this is about as low a piece of hanging fruit as you could possibly imagine. And we appreciate the work that the commission staff has done extensively on this issue. So we support Senator Blakespear's motion at this time.
Thank you.
Mona Masri.
Yes, hello, can you hear me?
Yes, we can.
Thank you. My name is Mona Mastry. I'm with Economic Security California. We're a policy advocacy organization that works to build an inclusive and resilient economy so that all Californians can thrive. And part of our efforts include fighting corporate concentration that stifles opportunity, harms workers, and disadvantages consumers. And we strongly agree with the recommendation that Senator Blakespear made that the commission move forward on revising California's antitrust law. Thank you.
Thank you.
Sorry, I apologize for not being able to pronounce her last name. Shinsekian?
Yes, can you hear me?
If you could speak a little louder, it would be greatly appreciated, but we can hear you.
Sure, thank you. My name is Lucy Chinkezian, and I'm counsel at the Civil Justice Association of California, CJAC for short. CJAC has been a trusted source of expertise in legal reform and advocacy for almost half a century. CJAC has previously provided written comments to this commission regarding the antitrust study. We do not believe there is a need for this commission to move forward with the antitrust study, and so we do not support the motion. There is no evidence to support the idea that the current state and federal antitrust laws are insufficient to address concerns raised by the legislature. Changing the law will impose significant costs and burdens to both businesses and consumers. We do have further feedback, but I will reserve them for later. Thank you.
Thank you for your comments. Do we have any additional?
The final request for comment is from Samantha Corbin.
Thank you, Madam Chair and Commissioners. I think I'm in the right spot now. I'm here and representing the Bay Area Council, an 80-year-old employer-sponsored public policy and advocacy organization whose mission is to keep the Bay Area region the best place in the world to live and work. My comments are also aligned with the LA Biz Federation here today. The Bay Area Council supports effective antitrust laws. The basic tenet of antitrust is to prevent abuse by market-dominant entities or monopolies that stunt innovation, new company startups, competition, and consumer choice. And we support good laws that prevent all of those things. But we also believe that efforts to make radical reforms to our current laws look very much like a solution in search of a problem. Existing federal and California antitrust laws strike the right balance between keeping in check potential abuses by market-dominant entities and fostering innovation and startup, and our data supports this position. According to recent research by the Bay Area Council Economic Institute, of the 50 largest U.S. companies by market cap, 17 are in the Bay Area, and 5 of those 17 are in the top 10. We are clearly a region that is incredibly successful at establishing and growing successful large companies. But at what cost, you may ask? What impact is this having on new company starts, on competition in the marketplace, on alternatives for consumers? As it happens, thanks to the current regulatory environment, we lead the world in all of those things as well. Between 2020 and 22, there were 27 venture-backed companies that had an IPO, SPAC, or direct listing valued over $10 billion. Of those 27, 18 were headquartered in the Bay Area alone. More than half of the private companies in the IPO pipeline valued over $5 billion have a Bay Area headquarters. We have 45 such companies. By comparison, New York has 14, and the whole state of Texas has only 2. Over 40% of US companies pre-IPO valued at $1 billion plus are headquartered in the Bay. Our region has 71 such companies, and by comparison, Chicago, Miami, and Dallas have only 2 apiece. In 2024, 54% of global venture investment in AI startups was in San Francisco-based companies. Between them, San Francisco and San Jose have 4 times the AI job openings as the next 13 metropolitan areas combined, and 35 of the largest AI companies in the world are here in California. The data is
Ms. Corbin, I have my apologies to interrupt. I do have a question.
Sure.
Is this argument for the motion or against the motion?
Against the motion.
Against the motion, okay. Because I think initially it sounded differently. Okay.
Great. The data is very clear. We're in a regulatory Goldilocks zone where large companies are able to thrive alongside a robust world-beating startup environment that is the envy of every other state in the union and many countries around the world. Our pipeline of new ideas, new companies, and new choices for consumers is huge. We urge you to proceed with extreme caution and with the mindset that if it isn't broke, don't fix it. And we oppose moving forward with this motion. Thank you.
Thank you.
Our next commenter is Peter LaRoe Munoz.
Good afternoon. My name is Peter LaRoe Munoz. I'm here on behalf of the Silicon Valley Leadership Group, a business association representing innovation economy companies on policy matters. I wish to express our opposition to the motion. The proposed changes here will drastically alter the state's antitrust law for the worse. While we support efforts to protect robust competition, we are concerned that the recommended changes would, if adopted, produce real-world harm for consumers and businesses. Existing laws have served California citizens well for more than 100 years, supporting the development of the world's most innovative economy. As the Attorney General's office can attest, our state and federal antitrust enforcers have used current laws to great effect to ensure California consumers receive the best products in the greatest number at the lowest prices. California also enjoys robust private antitrust enforcement. We understand the need to ensure a competitive playing field within our markets. Unfortunately, the proposals under consideration today would only reduce competition and deny consumers access to the highest quality and most competitively priced products and services. Thank you.
Thank you.
No more comments.
All right, I'll check in again with anyone that is here at the meeting. Do we have any public comment?
There's 2 more now.
Now there's 2 more. That's good. Great.
And just a reminder for the public commenters that the comment is limited on to whether or not the commission should move forward with the antitrust study.
Andrea Zinder. Andrea, yours. Andrea, would you like to speak?
Yeah, and if you could keep your comments limited to whether you support or are against at this time, there'll be opportunity for further public comment later.
Andrea?
Hello,
Yep.
We can hear you now.
this is Michael Stromwasser. Are you, have I been called upon?
Yes,
Oh,
yes,
thank
this
you.
is
I'm
your
terribly
opportunity for
sorry.
public comment on this very specific question.
Exactly. Yeah. I'm Michael Stromwasser. I'm counsel for the Western States Council of the United Food and Commercial Workers Union. We do have comments about the substance that we'll help make later, but on essentially the question of federalism, which is the question that has now been raised by the parties that are urging you not to take action. I would simply point out that federal law is not carved on stone tablets. Federal law has changed. Things that were illegal 40 years ago are now deemed to be permissible under federal law. Things that were permissible 40 years ago are not. And one can say that this is merely the inexorable march of progress and knowledge, but that is a naive and fundamentally erroneous contention. It cannot be denied that antitrust law in particular has experienced ebbs and flows that correspond not to the knowledge that economists or other technicians bring to the matter, but simply to electoral fortunes. And it would not be, California would not be well served by saying, well, if there's a change in the federal administration, whatever they say is fine with us. That is not the way the federal system ought to work. It's not the way it has worked. It's not the way that the opponents of this motion would want it to work if the tables were turned. So the Western States Council urges the commission to adopt the proposed motion. Thank you.
Thank you.
Last one is Donnie Tedesek.
And again, if you could limit your comments to whether you support or oppose the motion, there will be opportunity for more detailed public comment later on.
Good afternoon, folks. My name is Doni Tedeschi. I'm here representing Rise Economy. We're a member-led alliance of around 300 nonprofit organizations throughout the state dedicated to creating systemic change and economic justice for BIPOC and low-income communities. We fully agree with the motion to move forward on revising California's antitrust law. Thank you very much, and we look forward to providing more extensive comments later.
Thank you.
So, Madam Chair, it's up to your discretion. It sounds like we continue to have persons raise their hands. There will be opportunity for additional public comment. We do have a motion on the table. Do you want to take more at this time?
How many people do we have?
Like we have one more.
Let's take the one more. I want to make sure that the next commenter very clearly states in the beginning, are you opposing? Are you a proponent? And if you have urging need to say the reasons why, please say so, but keep that very brief.
Travis West?
Hi there, can you hear me?
Yes, thank you.
Wonderful, thank you. Travis West, Regulatory Policy Specialist with California Nurses Association, the largest union and professional association of registered nurses in California, representing over 100,000 RNs across the state. We would like to reserve the opportunity to comment on the further specific questions, but with respect to this specific item, we would like to say that we strongly support the currently pending motion to move forward with amending the current law. Thank you.
Thank you. All right, so I think at this time, we are done with public comment.
There's one more.
One more. I think I'm gonna go ahead and just because this is a threshold question.
Okay.
I think it's important that we give that space. Again, please keep your statements. Let us know from the get-go who you are, who you represent, if you oppose or you're for it, and if there's any urgent thing that you need to say about that.
Bianca Blomquist? Bianca?
Hey there, thank you so much. My name is Bianca Blomquist. I'm California Director for Small Business Majority. We are a national nonprofit organization advocating for 85,000 small business owners across the country who have a vested interest in the goings-on of this commission. Thank you so much for your work over the past number of months. We agree with the recommendations put forth by the CLRC, and thank you so much for your time and consideration.
Thank you. Great. We are done with public comment. Thank you all. It's great to see the enthusiasm that everyone is showing in sharing their perspective. We need that. We have a lot to cover, so we will be trying to move these meetings as efficiently as possible while providing the opportunity to have everyone be able to speak. So please be considerate of each other as well as the process. And we will continue.
So we do have a motion and I think a second on the table.
Yes.
And I will call the roll after just simply clarifying that the only thing this motion is asking is whether the commission approves the staff recommendation to move forward with the antitrust study. There's a lot more detail in as we move through the meeting. So with that, I will call the roll.
Please, thank you.
Commissioner B.
Aye.
Senator Blakespear.
Aye.
Commissioner Carrillo.
Aye.
Commissioner Carrion.
Aye.
Commissioner Hebner.
Aye.
Commissioner Jenkins.
Aye.
I do not see Assemblymember Kalra. Are you, are you there?
Aye.
Okay, there you are.
Aye.
Thank you. Commissioner King
Aye.
and Commissioner Simpson.
Aye.
The motion passes. You can continue.
Okay. So the next question, which is now we're getting into, okay, we're gonna do that. We're moving forward. What should it look like? Commission, what do you want the staff to work on? And so the next question is, should California have its own law on single firm conduct? It's kind of a two-part question, as I'll try to briefly explain. And Cheryl, if I get something wrong, please interrupt me. California's main antitrust law, the Cartwright Act, generally does not apply to conduct by a single firm to monopolize excluded competitors or cause other competitive harms, rather it focuses on the actions of two persons. As we move through the study, we learned that there is a broad consensus of the academic and enforcement communities that California should adopt legislation reaching single firm conduct. It's worth noting that California is one of only a few states with antitrust laws that do not address single firm conduct. And thus the state can only pursue anti-competitive single firm conduct under the federal Sherman Act. Adopting a single firm conduct provision would allow California state courts to adjudicate California antitrust claims and reduce its reliance on federal enforcers. So the staff, so the first question, then we'll have two subparts under that. The first question is, does the commission agree with the staff recommendation adding a provision to address single firm conduct to California's existing laws? I will defer to the chair now.
Yes, I think we'll take that piece by piece.
Okay. Okay, so that makes perfect sense. So the two sub questions are, one option would be to simply, if the commission wants something, you know, a section 2 like thing for California, one option would be to just mirror federal law in its entirety. The issue for consideration by the commission is adopting federal law by simply importing the Sherman Act Section 2 into the Cartwright Act would likely be the least disruptive option for including a single firm conduct in California law. But however, moving to the second question, so the option 1 is just copy the federal law. Option 2 is, should California adopt its a single firm conduct standard that is a California version? Many experts cautioned against California adopting Section 2 in its entirety. By doing so, California would effectively import the decades of federal jurisprudence that has interpreted that law. So I think there was a lot of the feedback we got was that it would be better for California to draw on Section 2, but to tailor it to the unique needs of California. And part of that is it would include language implicitly rejecting the effects of US Supreme Court cases that have weakened antitrust enforcement and could there are other examples, you know, that we've looked at in terms of other legislation or single firm working groups recommendation. Obviously, you know, staff is not suggesting any specific language at this time, but wants to get the commission's view on if the commission believes that the commission should further study adopting a single firm conduct provision and whether that would just mirror federal law in its entirety or whether it should be tweaked somewhat to address California's unique challenges. I'm looking at Cheryl to make sure I'm saying this correctly. And one of the important things is making clear that California is not bound by certain federal precedents, which there does seem to be some confusion at the federal level about how to follow those precedents. So the staff is recommending that the commission move forward with studying a recommendation that would do more than mirror federal law, that would tailor it to the unique needs. It would not obviously be building on Section 2 of the Sherman Act, but tailor it to the unique needs and experience of California.
And just for clarification, I think in terms of single firm conduct, when we talk about mirroring federal law, we're talking about importing Section 2 of the Sherman Act as opposed to adopting the whole body of federal law. And so the issue is, do we just use like a section 2 of the Sherman Act with respect to single firm conduct? Or do we Californianize it and make it more flexible and more responsive to California's interests and values?
Thank you for that clarification. I will remind commissioners as well as the public that we are looking again at a discrete question right now, and that's how we'll be proceeding with this memorandum. So the question is, do we mirror the federal law, Section 2 of the Sherman Act, or do we make a California-specific law? I see that Commissioner Carrillo has a comment or question.
Thank you, Madam Chair. Since I'm a state constitutionalist, my default position is almost always going to be California should apply California law. And in this instance, it's no different. California should have its own law here. So I would suggest that the commission consider taking up the second of the two options that's on this particular topic of drafting California's own version of Section 2 of the Cartwright Act. That could include stealing, borrowing, plagiarizing, the text of it. The closer we get to it, the more clear we're going to have to be that we're stealing only the language and not the subsequent case law body of doctrine that's developed around it. But whatever direction the language winds up going in, my suggestion to my colleagues is that California chart its own course on this issue, and I'll probably make a similar comment on the other issues as well.
I also like to know, let folks know that I concur with Commissioner Carrillo's comments, and I'll ask my other colleagues. Are there additional comments or questions?
Yeah.
Yes, Vice Chair.
I actually kind of see this as a sort of a two-part question. One is, should we have a single firm law, yes or no? And then subsidiary to that is, what should it look like? Because at the moment, it sounds like we're being asked to vote on copying federal law or writing our own law. And I think the first, I mean, I could think of some people might say, well, we shouldn't do single firm, but we should do something on mergers and acquisitions or whatever. So it strikes me that this is a two-part question. One, should we have a single firm law? Secondly, what should it look like? So that would be my suggestion how we proceed. Now, I think we should have a single firm law. On what it looks like, I certainly concur we shouldn't copy federal law, because if the purpose of doing single firm law in the first place is not to have to rely on federal jurisprudence and federal courts, then that seems pretty simple. What should it look like? There was one of the drafts from one of the study groups that basically took Section 2 and made some changes to it. I wouldn't do that either, honestly. If the purpose is to not California judges not use federal decisions and whatever to judge a case, if the language that they're being asked to adjudicate looks a lot like federal law, the argument for not using federal precedent seems to be a lot harder. I actually talked to a friend of mine who's a judge, and they had the same view. So my view about if we do it, what should it look like, is we ought to go into the Cartwright Act and make as few changes as possible to have the things that are unlawful for multiple firms also unlawful for single firms where applicable. And there may be some things that one needs to add to apply to single firms that wouldn't work for multiple firms. But I'm a proponent of the KISS principle. Keep it simple, stupid. And so that's the kind of a statutory changes I would be thinking about.
Commissioner King?
Yeah, I think we need to move things along. We have a lot of things on the agenda, and I think you hit it right on the head. And so may I suggest you give the motion for exactly that, combining everything into one motion, so that we can vote on that. I think everything you said was very reasonable, and I agree with it wholly. And if we just put that on the table, we need to move on to the next item. You want to make the motion and second?
Okay,
To combine it,
I will move what I said.
a single firm,
Yes, there ought to be single firm. I think that's I don't know if other commissioners.
We'll still have an opportunity to continue questions and comments if you make a first and a second motion. If you want to wait until you hear from other colleagues in the public comment, that can happen as well. But I do appreciate Commissioner King's recognition of how much we need to cover.
and to keep it simple, the motion should be, should we proceed with a single firm concept and have it different from federal law?
Okay.
I'd make that motion.
All right,
I'll second it.
great. Now, additional comments or questions from commissioners? I see none. Now, public comment, again, we are looking at number one, whether we should have a single firm conduct rule in California, and second, whether it should be federal or California-ish.
And please, if there are public comments, please try to limit your comments to 5 minutes.
Yes.
Robert Harrell.
Thank you again. Commissioners, Robert Harrell, Executive Director of the Consumer Federation of California. I'll save about 4.5 of the 5 minutes allotted and say we support the motion wholeheartedly. Thank you.
Thank you. Okay. There's public comment in person. Please come to the podium.
Great, thank you, Madam Chair. So my name is Dan Robbins. In this capacity, I'm representing the Motion Picture Association. That's the trade association for the United States film industry. We are the top producers and distributors and streamers of motion pictures and television streaming content, all based on in a city down south that's in fire, and hope to get past that. This is sort of some things have been combined here.
So number one, should we have a single firm conduct?
So we sent in a letter in October saying if you wanted to do that, we'd certainly be willing to work with that. But I think there was a subpart to the motion, which is, should mirror the Sherman Act or should it be something different, right? Okay, so our view is that you should start with the Sherman Act and make changes as needed. The Sherman Act is something the whole antitrust community is familiar with. We in California have taken this approach in the past when we didn't like the Illinois BRIC indirect purchaser decision of the Supreme Court, I think in the late 70s. We passed a law that invalidated that as applicable to the Cartwright Act. So we could take the Sherman Act, put it in the Cartwright Act, we could make changes. The cases we didn't like, we could repudiate. We've done it successfully in the past. The benefit is that it's enhanced predictability. In contrast, the Motion Picture Association is opposed to the abusive dominance test. We're opposed to the New York bill. We're opposed to the single firm conduct group's report. Just very quickly, that report abandons things that we've used for many, many decades: relevant market share. These are critical tools that compliance people like me use to give advice. And if those are taken away, we're sort of cast off into the darkness. On the abusive dominance side, as the report notes, that's used in Canada and Europe. It's also the prevailing standard in the People's Republic of China. It's used by the Communist Party, the SMR division. So it's used in a lot of places. What all those things have in common is these are places where the government is pretty much the sole enforcer. What the Chinese government does, there's no private lawyers to interfere, at least not for long. So in our system, though, we have a ton of private enforcement, and that's different. And so we might get different results. There's a lot of uncertainty. And I guess the last thing I would say is, when I saw this in the New York bill, just one quick example, it had this presumption that if you had more than 30% of the market anywhere in New York at any time, that's a felony. Like that can't be the rule. So there's a lot of problems that you would import if we decided to bring that in. So
Question, because it sounds, and maybe it's, I'm not understanding it. It sounds like you are sort of conflating single firm law with the abuse of dominance standard. And first of all, is it, I mean, am I reading that correctly?
Abuse of dominance is single firm. It's a flavor of single firm.
But that is one way of enforcing single firm, it seems to me. I mean, the law could specify things that are illegal. Just, you can't do this, you can't do this, you can't do this, period. It doesn't, I don't think it necessarily has to say, with an abuse of dominance, you can do this sort of thing until you reach X percentage of the market, and then you can't do it anymore, and then it's illegal. I mean, those are two different ways of, if I'm reading it correctly. So it doesn't strike me that having our own single firm law and having it reflect California's values or whatever is necessarily the same thing as using abuse of dominance as the way to enforce it. Is that
right?
Am I correct in that?
Yeah, we don't. So what the single firm working group considered is they looked at all these things. They looked at abuse of dominance in New York and rejected it, and then they proposed their own 3.5-page new rule. But yeah, you could do a single firm conduct law. You could have abuse of dominance as its foundation or not, or something else. You could have the Sherman Act as its foundation and make changes like I've suggested. Those are just different flavors of how you could address it, all within state law.
Right.
So agreeing with your fundamental premise of this is going to be part of the Cartwright Act, it's just how do we build it? Great, thank you.
Thank you. I believe we have virtual comment.
We have two commenters, Mona Masri.
Yes, hello, Mona Mastery with Economic Security California, and we wholeheartedly agree with both options. Thank you.
And just to clarify, does that mean the motion on the table that you agree that there should be a rule then that it should be a California specific rule?
Yes, that's correct.
Okay, great, thank you.
Next and last is Ben Golombek. Ben?
Thank you, appreciate it. On this specific point.
Mr. Goldman, can you please speak up a little bit? We can hear you, but it's a little hard to hear.
Sure, is that a little better?
No.
Not much.
Okay.
Yeah, much better, thank you.
Okay. I will, we disagree with the motion. I will say that on this specific point from the staff's recommendations, we see it as a dramatic shortcoming that they do not conduct or rely upon any sort of cost-benefit analysis of the effects of amending California's antitrust laws. And the inherently antitrust policy includes antitrust policy making has trade-offs. It can deter and punish anti-competitive conduct, but can also deter and chill aggressive competition and innovation. And by chilling pro-competitive conduct can harm consumers and the overall economy in the same manner as anti-competitive conduct. This is why it's critical to utilize a cost-benefit methodology to determine whether new policies on balance improve economic performance and efficiency. And so for this reason, we urge the Commission to not take action on this item until it's clear that the trade-offs associated with amending California's antitrust laws are on balance beneficial to California consumers, businesses, and workers. Sound public policy demands as much. Thank you.
Thank you. Do we have any in-person additional comments? Please.
Thank you all. Good afternoon, Commissioners and Chair Carrion. My name is Ben O'Brien. I'm here on behalf of California Life Sciences. We're a trade association representing 1,300 organizations, including biotech, pharmaceutical, medical technology, and academic research institutions. around the state committed to advancing innovation and improving health outcomes. On this particular item, we are also in opposition. We have a couple concerns over the proposal to expand the Cartwright Act, particularly as Senator Blakespear was mentioning. In our sector, there are a lot of pro-competitive mergers and collaborative agreements that are really important in pushing innovation forward and bringing new treatment options to market for the patient population that we're advocating for. So we just wanted to raise those potential concerns if you're considering the Cartwright, expanding the Cartwright Act as an option for the single firm conduct.
And do you have a position as to whether we should have a single firm conduct and whether it should be federal, California?
Right, our organization is against a California specific single firm conduct reform, as we kind of feel like that would add an extra layer of regulatory burden on our companies.
Okay, thank you. All right, no additional public comment at this time. Moving forward with a roll call.
Okay. I will move forward and try to catch who's still with us. Commissioner B?
Aye.
Senator Blakespear had to leave. Commissioner Carrillo?
Aye.
Commissioner Carrion?
Aye.
Commissioner Hebner?
Madam Executive Director, could you read the motion for me? What is the specific motion we're voting on?
The motion is whether we should have a single firm conduct rule. And if so, what it will look like. Should we apply the federal law or should we have a specific California law?
And just a little clarification.
Yeah, the motion isn't an either or. The motion is to move forward with a California oriented.
Yes, thank you so much. I appreciate that, Commissioner King.
Aye.
Okay, thank you.
Thank you.
I don't see Commissioner Jenkins. I do not see Assemblymember Paulra. There you are.
Aye. Aye.
Commissioner King.
Aye.
Commissioner Simpson.
Aye.
The motion passes.
Okay, I'm probably gonna need help.
Kara's back.
Okay.
Sorry. Aye.
Oh, all right.
Thank you.
Okay, thank you. Let me just
Continues
get that.
the
Okay. Okay, so now we're going to talk a little bit about abusive dominance. And I might need to ask Cheryl for a little bit of help on this one. It's a pretty complicated concept, but the proposed reforms that were noted in ACR, the New York 21st Century Antitrust Act, and CALERA, the federal law, both contain an AOD abusive dominance provision that makes it unlawful for a dominant entity to abuse that position to its competitive advantage. So that was something that was specifically put for the commission's consideration in ACR 95. It does draw on European Union law. However, AOD is practiced in abusive dominance as practiced in some foreign countries, likely has definitions and procedures that are not suitable for California's economy or legal structure. And so if that's something that the commission wants us to further study, we're gonna have to do analysis and explain, what makes sense for California in this context versus what we see maybe in Canada. Many consider that some sort of abusive dominance standard is essential to challenge dominant countries that defy a ready application of the Broad-Sherman Section 2 Act. Section 2's broad prescription of attempts to monopolize could be read to meet competitive challenges of dominant companies. But in practice, as our expert can tell us, it has not been that effective. And the concerns about abuse of dominance have been heightened with the emergence of big tech, which we'll talk a little bit more about. The staff isn't speaking to any specific formulation for this approach at this point. There would be a wide variety of different formulations that the commission could consider to identify dominant actors from using specific percentages of market shares, et cetera. There would be a lot more detail that you would need to consider. So just the threshold question for today is, does the commission want staff to draft language and do analysis that would lead to perhaps integrating elements of an abuse of dominance standards that guards against the misuse of market power to a new single firm conduct provision, which the commission has already directed staff to move forward with the new single firm conduct provision. This is okay. When we're doing that, does the commission also want to see something about abuse of dominance? And I'm going to ask Cheryl if she has anything to add. Did I get it?
Absolutely. So the problem that a lot of people consider is that Section 2 has not been effective in its application to some of the largest dominant firms. And one of the flavors or responses to that is some sort of standard that draws on abuse of dominance, which is in use in many, many different countries around the world, or misuse of market power. And I know this bleeds into both single firm conduct and big tech conduct, but we decided to deal with it as a separate topic. So it really affects 2 or 3 other different issues, but that's why we kind of singled it out.
Yeah.
And there is no real standard. I mean, we talk about it being a complicated concept, but we're saying, do you want us to even look at it? Some countries have made it a very complicated concept and others have very simple definitions. So there's no set standard that we're talking about here.
Commissioner Carrillo, you have the floor.
Thank you, Madam Chair. I think this is the one place where I diverge from the staff memo. And again, it flows from my state constitutionalist perspective. If, in my view, if borrowing federal law is bad, borrowing from international law is even worse, for a few obvious reasons. One is that I can't speak to Canada, but I know that the European Union is primarily a civil law system. So to the extent that we'd be importing any of their concepts, we're importing from a completely different judicial system, which sets up some fairly obvious conceptual problems right at the outset. I'm also troubled by the fact that the European abuse of dominance standard employs a fairly arbitrary percentage standard. 60% is what sticks out in my mind. Regardless of whether I'm right or wrong about that number, any number is inherently arbitrary in this context. So I'd be concerned about that. Whatever number we come up with, if it's the same or different, it'll suffer from the same arbitrary line drawing problem. So where I wound up on this was I feel like the commission is going to, or the staff, at least initially, is going to have to come up with what California's definition of single firm misconduct is. I'm not sure that it should be borrowing from abuse of dominance jurisprudence. We'll have to come up with something, but this is one thing that I would be reluctant to borrow from.
You both
Good.
at the same time here.
I'm a contrary view because I don't presume that we're necessarily going to just wholesale or substantively adopt the European standard. I think this is an invitation to look at various standards. And I lean more towards the side that there is a problem that needs to be addressed rather than worrying about being too specific on the solution. So I will support a motion that makes the staff recommendation actionable, but I am no way saying that we need to adopt bad standards. We need to research and get input on what a good standard would be.
Vice Chair?
I tend to agree with Commissioner Carrillo, the thing that bothers me is having firms that are big and that have huge market share because they're the best at what they do. That seems to me to be okay. That not because they've done things that harm their competitors, but because they're best quality, most efficient, whatever, and they can dominate the market because they're better at it than everybody else. People who become big because they harm their competitors by various ways, that seems to me to be a problem. And so what this feels like to me is it's saying there is behavior that you can undertake when you're starting off that you can't then undertake after you reach a certain threshold of market power or dominance in the thing. And I mean, not having seen much of examples of what that are, maybe Cheryl's got some examples of what that would be, that makes me uncomfortable. I'm more of the view that we ought to try to, in enforcing single firm law, anti-competitive behavior in single firm law, kind of the same way I think we do for collusions between two or more firms. That if there's things they're doing that are per se illegal, the purpose isn't to benefit consumers particularly or benefit, it's to harm their competitors. Those are things that ought to be illegal and prosecuted, I guess, either through civil law or AG or whatever. But presumptively, having behavior you can undertake when you're small that you can't then undertake when you're big. That's what abuse of dominance strikes me as, makes me uncomfortable.
Commissioner Carrillo, and then after Commissioner B.
No, a Assembly Member Calro was ahead of me, and so was Commissioner B. I can wait.
Oh, thank you so much. Go ahead, Commissioner B.
Oh, I think you said Colorado.
Commissioner Colbert was next.
He's not on.
Once he turns his camera on, he'll.
Oh, I see. We aren't able to see folks unless you put your camera on.
Oh, there we go.
No, thank you.
The Golden Gate Bridge.
Hello, everyone. Yeah, I actually support the staff recommendation. Again, you know, the abuse of dominance standard is one I think that's important. Of course, it's not a factor in and of itself, but I think that it's definitely one that needs to be part of the standards that we adopt. And again, I for those that mentioned concern about looking at international standards, what have you, I think we have to look at all models that exist out there and then craft and tailor one that works for California. I think this is an issue that the legislature is probably, my guess would be one of the many different areas that will at least be of interest. And again, as I said earlier, I think it's really important that the work of this commission continue to help inform the legislation that is being considered. And I think this is one area where the commission can offer great expertise and the ability to ultimately, if there is legislation that's crafted, to ensure that it's crafted in a manner that still allows for you know, the competitiveness of California companies while ensuring that we're adopting a program that does at least factor in that kind of market dominance as well. And that's certainly a factor that should be considered when we're thinking about antitrust laws. And, you know, and I think, and I believe and trust the staff and those experts that they bring in to craft their recommendations, that as they move forward, they'll also offer a menu of different options and facts and figures and expertise that will allow us to arrive at a decision that will meaningfully inform the legislature as the next steps. So I do support and happy to make a motion to support the staff recommendation at this time, and obviously the conversation will continue from there.
Okay, so there's a motion on the table to support the staff recommendation from Assembly Member Carlo. Commissioner Carrillo, you had a comment?
Commissioner B still needs to go.
Okay, all right. I'm not too sure. I apologize. It's a little difficult to see who was first on the screen, but I appreciate your patience, Commissioner B.
Oh, not a problem at all. So I support the motion. As I sit here, I don't know whether it will make sense to adopt an abuse of dominance standard. I think I need to see what the staff comes up with, right? The research, the proposals. It may be that at the end of the day, I don't agree with it. It shouldn't be part of it, or staff may do some research and realize, it's not appropriate here. But as I sit here today, I don't know, and I think it's worth looking into. So I support the motion because I think conceptually, the abuse of dominance standard could be very helpful.
Now, my position is that I also agree with the motion for the reasons stated by Commissioner King as well as Commissioner B. Do we have any additional comments? And Commissioner Carrillo, see, I gave you opportunities.
I will now step up to the plate. I just was going to say, I don't disagree with what Victor said. And I'm going to refer to something that Rick brought up earlier, which is that there's more than one way to skin this cat in terms of having a standard that in this context defines what is single firm misconduct. It could be an abuse of dominance standard. And that particular abuse of dominance standard could be something that we borrow from the Europeans. Could be a percentage. The staff memo on page 8 in almost the last paragraph of this talks about there's no specific formulation for this approach. It could be a set of principles like the European style abuse of dominance percentage standard, or it could be specific actions that are barred by statute. So if as I understand the motion is, should we look into whether an abuse of dominance standard, whatever that looks like, is a way of enforcing single firm misconduct? I'm not opposed to that. But if the recommendation comes back with, we should borrow the European standard and impose a 60% market share marker for you're now a dominant firm and you're abusing it, that I would have a significant problem with for the reasons I've stated. But in general, I don't disagree with Victor or Rick's comments on this. And I think I'm okay with the motion as I understand it. And Victor's going to say something.
Now, to clarify, is that what the staff is asking?
The staff is basically asking, you want us to give you some proposals. It's always going to be up to the commission to say, we're looking at the staff analysis, you weighted the pros and cons, we just can't get there. And
yeah, let's look at
it. So that's the way it would be presented.
May I suggest a semantic distinction that may be helpful? And you could say I'm thinking about this too much, but in the staff memo, it says, we should consider that something may be helpful is a California adoption of an AOD-like or misuse of market power approach. So I might well propose having a motion to say, we want the staff to move forward with a misuse of market power approach, as opposed to the abuse of dominance standard. Because the abuse of dominance standard, as Professor Carrillo has pointed out, does kind of imply a European Union orientation. These are just words. And we don't want the public nor lobbyists to get off the rails thinking that because we use the term abuse of dominance that we're trying to make this a European Union law. So let's just avoid the words. And as staff has pointed out, we want to consider a California adoption of an AOD-like, and it's kind of silly to make a motion saying I want to support an AOD-like. So I'll take the other phrase that they use, which is a misuse of market power approach. So I recommend modifying the motion to be, we are agreeing that staff should move forward with a misuse of market power approach.
Assemblymember Kalra, would you agree to that modification?
I'm fine with the way the staff has it, actually. I think it accounts for that. I mean, I think at the end of the day, staff is going to provide, their expertise and their options as to how we move forward. And, and so I mean, we can wordsmith or what have you, but the reality is that the ultimate motion gives staff a wide discretion to provide a lot of options to us. And we can, as mentioned, can decide to move forward with some or none of the options going forward. But I don't think that we should have this instinctual fear of using the abuse of dominant standard simply because, it's, it might be mimicking terminology that's used in other jurisdictions. Ultimately, the staff's going to bring us a wide range of options that deal with that misuse of market power. And so I'm personally fine with the way that it is.
Thank you. Commissioner Hubner.
Yes, just a question for point of clarification. Are we talking about an abusive dominant standard with respect to single firm conduct or something broader? Because the memo in this section talked generally about the tech sector, which seemed to move past single firm conduct and into a particular sector where there might be multiple firms engaging in the same activity. And I always like to know exactly what I'm voting on.
So
practice.
So this one in the staff recommendation, it's limited. It would be some abuse of dominant like standard relating to misuse of market power in a proposed single firm conduct provision. Do you have anything to add, Cheryl?
No, it's
So
a
that is
single firm conduct concept.
So that's a very narrow framing.
Yes.
Okay, thank you.
Yes.
Maybe for Cheryl. Is this, if we move forward on this, does this mean identifying conduct that is only unlawful if you have a certain level of dominance in the market? And what kinds of things are those? So it's not unlawful if you're a small firm, but it's only unlawful if you're a big dominant firm. And what kind of conduct is that?
It's when a dominant party misuses their market power, for instance, to engage in predatory pricing, to put out all their competitors and then to take over the market afterwards. Now, predatory pricing may not be unlawful. In fact, maybe pro-competitive if somebody is pricing their goods very low, but they're a small player and they're not putting people out of business. Self-preferencing, you hear a lot about self-preferencing, and a lot of people talk about, well, if you have a Google that self-preferences its own products over the products of everybody else, but is running a network, so that may be unfair and may put a lot of people out of business. On the same hand, a small company self-preferencing is what you do. I mean, that's the lifeblood blood of competition. So size and market power does matter in terms of the effect of the conduct.
Yeah, that still bothers me. I get what you're saying. Okay, thank you.
Commissioner Carrillo?
Yeah, I have a comment and a request to Assemblymember Kalra. I suggest that you consider adopting Victor's friendly amendment to your motion, because I agree with Victor. I think that the wording here matters. He had his own reasons for it. I actually think that it's substantive, because if the motion is to have the staff explore an abuse of dominance standard, that necessarily limits us only to whatever that dominance threshold winds up being, 50%, 75%, who cares what the number is? So the recommendations that are going to come back are, here's how you tie misconduct to whatever market share a company has. And the threshold that you set is going to be exclusive. Anything below that market share, you can't use this concept to charge single firm misconduct. Taking the abuse of dominance language out and using Victor's broader misuse of market position phrase, it actually expands it, and I think doesn't tie us to only considering options that are defined by that arbitrary market share percentage that I spoke about earlier as troubling me. So I think it'll liberate the staff to a certain extent. It'll avoid tying our hands in terms of what recommendations we can consider, and it'll avoid that problem that we're ultimately going to have to circle back to if we're looking at abusive dominance options. They're all going to have a percentage in them. All those percentages are going to be arbitrary. We're going to have an incredibly difficult time justifying which one we land on. And I think we cut that off and avoid that problem entirely for ourselves by going with a broader, non-specific, not tied to European concepts of abusive dominance. So I hope you'll reconsider and accept the friendly amendment.
Well, I think it makes a presumption that there aren't elements of an abusive dominance standard that we would want to have in there, or I understand you're saying it's inclusive of it, because it could be, but the motion or the staff recommendation to integrate elements of an abusive dominance standard, it doesn't prescribe any outcome. If the staff wants to elaborate on that, I mean, by saying integrate elements of abusive dominance standard, does the staff feel that like, for lack of a better word, handcuffs them to having to have a percentage that they come forward with, or give elements that, or can they give options that include percentages or might include other elements of the abusive dominance standard? That's what, because I think it's important. Look, ultimately, and I know there's some folks that have a problem with the idea that firms get to a certain size, that by itself or in and of itself shouldn't be a trigger, but ultimately that is a major factor. Look, I mean, where the work that's being done here is not happening in a vacuum, and we heard earlier, from some of the public comment on the initial question, there is an administration that in the federal government that is not necessarily going to be as cooperative working with us. That's just a fact of the matter. Maybe as elected official, I think about that more than others that might be on the commission. But there was an inauguration where major firm players were still sitting in the front row, right behind the president. And so to say that abusive dominance standard is something that we should not, have some degree of analysis of, I disagree with. Now, does that mean other, again, it says integrate elements of some of that abusive dominance standard certainly could incorporate percentages, and we can ultimately decide as commission, that's not where we want to go because it is too complicated. And there might be other aspects of it that we want to incorporate. As Commissioner B said, that this by supporting this, we're not saying we're agreeing on an ultimate conclusion, but we're allowing the staff to bring forward all those options. Now, if it's integrate elements of abusive dominant standard and other mechanisms that may be of use, that other mechanisms that other jurisdictions might be using to the same end that guard against the misuse, then that's fine. That's fine. But I don't think by itself just removing that is going to lend itself to have all the options on the table. I think it's important to see what is being done with the abusive dominance standard. And ultimately, we can brush it aside and determine, as to your point, Commissioner Carrillo, that it's not going to work because it'll be too complicated or it doesn't actually get to the root of what we're trying to achieve. But I actually like the way that the staff recommendation has articulated it. And if, I don't know, staff wants to comment on how broad because the recommendation seems pretty broad to me of how broad it is, or if they feel that it needs to have other elements or to ensure that they have a wide range of options to bring to us eventually.
So should I respond?
I believe that Commissioner King has a comment.
Okay.
would you like to hear staff speak first, or would you like to?
No,
make a
I
comment?
need to address the assembly members' comments because I feel much more strongly now that we need to use the misuse of market power language, because I'm on this commission not because I care about big tech. I'm on this commission for the agents. Cartwright Act, the Sherman Act, 100-year long laws.
I'm sorry.
It won't be big tech.
I believe somebody has a, there is background noise, so I would request that anyone that has, great, thank you.
Okay.
You were saying.
In a couple of decades, it won't be big tech. It'll be big bioscience. It'll be big AI. It'll be big whatever. And the remark that we should be concerned, or even talking about the fact that there were billionaires sitting behind the president at the inaugural, is unhelpful. We're not here to declare war on big tech. And that's my segue to my comment in the next vote that we're gonna have. We need to stop using the words big tech. Because big tech is colloquially defined as, these 6 or 7 prominent companies. I am not here to declare war on the 6 or 7 companies. I am very worried about market power abuse, whether it be tech or bioscience or artificial intelligence or quantum computing or DNA hacking. And these are all technologies that are going to come up in the next 100 years. So if our focus is on billionaires and their dominance, that is not why I'm here. And also is going to just bring out the lobbyists. Dominance means something in our society at this point. It means certain individuals who we could all name who run these large companies. And that should be our focus. My concern is market power, not dominance. So if Professor Carrillo agrees, I don't have a second on my motion.
Well, I believe we have one motion pending, and that's Assemblymember Carla, so there's not a competing motion until we finish that motion.
Yeah, that's why I didn't second. I'm waiting for us to clear the first motion off the table.
Yes.
So just for staff to chime in a little bit, part of the reason we have these meetings is to hear this kind of robust discussion, and that informs what the staff is going to be looking at moving forward. So unless the commission voted to direct staff to only look at abuse of dominance, that's what you have to bring back to us. I think that the way that the memorandum is written, it gives us enough flexibility to accommodate what the assembly members asking for, what Commissioner King and others are asking for. I don't think it's tying our hands unless somebody disagrees.
I'm sorry? That was directed at me?
No, I don't think, no, it isn't directed at anybody necessarily. I think that we've heard everything that you all have said, and we can take it into consideration regardless of what the memo is, unless you said, no, the only thing we want you to do is abuse of dominance, don't bring us anything else.
Well,
But I bet that's not what I'm hearing.
I understand that you appreciate the nuances.
Yeah.
But the press and the internet trolls don't. So if we pass a motion saying, oh, we're going after abuse of dominance standard, it will be translated by certain people and interests as saying, oh, they want to do European Union percentages.
Understood.
That's what I'm concerned about. I'm making a purely political statement. I'm not saying a substantive statement. I want to see the work of this commission pass. You've heard me say that I was extremely frustrated. We spent 4 years on mediation confidentiality, and it was utterly wiped out by an army of lobbyists. I think if you say that the commission voted on this day to pursue abuse of dominance, it will bring out an army of lobbyists. And especially if the focus is on the dominance of big tech, and I really want to strike that word from all of our future studies, we should find another euphemism. We're not here to undominate big tech. We're here to be mindful of market power to make the state more competitive.
Madam Chair, point of order, could I get the text of the motion as it currently stands, please?
Yes, the text of the motion is that the staff recommends integrating elements of an AOD standard that guard against the misuse of market power to any new single firm conduct provision. And Assemblymember Carlos is to approve that.
Okay. I would call the question if there's no further discussion.
Is there public comment?
I don't know if we're there yet.
I'm sorry,
Do the commissioners have more?
do we have any additional comments, questions from the commissioners?
Yeah.
I believe so. Commissioner Jenkins?
I'm just curious, based on the discussion that's been had thus far, if staff have a recommendation to reconcile the recommendation so that, I mean, I get, it's like everyone, I understand everyone's points of view. But I am concerned, the one concern I have is that if this results in one sort of provision that comes out of the staff recommendation and not several options, we might be under the, we might not be seeing different options, and that we're sort of kind of getting the impression we would have, that we're evaluating different things.
Yeah, I'm gonna throw something out here and see what our antitrust expert thinks, but what if we said the staff recommends proposing a standard or proposing standards that guard against the misuse of market power to any new single firm conduct provision?
Yeah, I think misuse of market power is a very broad term that would encompass kind of elements of abuse of dominance without all the baggage which that term does. And I think it would be good just a friendly amendment, just to say, should we pursue options under a misuse of market powers?
Could we say including a abusive dominance standard?
No, that speaks for itself. If you're gonna address market power, you're gonna consider abuse of dominance among other things.
Vice Chair?
I think what Cheryl said was better, because right now the way it reads to me is what we're doing is what we're asking staff to look at is abuse of dominance, the purpose for which is to guard against the use of market power. As opposed to what we're asking them to look at is how do we guard against the use of market power as the thing we're doing. That's the tool as opposed to the.
So you're changing your position. Because you wanted us to go with AOD.
No, I didn't. I
Oh,
was the opposite. Yeah.
Oh, all right.
Anyway.
All right, so we have a motion on the table. Assembly Member Kalra, would you accept the friendly amendment of the language as proposed by staff? I believe you're on mute, so we cannot hear you.
That's to integrate elements of just make it more generic standards.
That's correct.
I mean, it seems like, based upon what I'm hearing from my fellow commissioners, that it appears that they want a little bit more flexible language. So I'm okay, with that, based upon what I'm hearing from some of my fellow commissioners. Not comfortable with just having AOD singled out as the standard to be examined, as long as AOD is examined in addition to other standards that are available or other research that can be done by the staff with the ultimate goal of guarding against misuse of market power. I'm fine with that. It seems like that's kind of generally where a lot of the commissioners seem to be landing, and so I'm fine with that.
Thank you. I will second Assembly Members Carla's motion with the friendly amendment. And unless there are additional comments from Commissioners, we'll move on to public comment.
Could we
Do
get
we have
could we get the text of the motion before we do public comment?
Yes, I believe yes. Can you
Okay, so
reread it?
we're
Thank you.
changing the recommendation to the staff recommends proposing standards to the commission that guard against the misuse of market power to any new single firm conduct provision.
Thank you.
Thanks. Do we have any in-person comments? Yes.
Good to set closer. Thank you, Madam Chair. I think that's a good direction. So Dan Robbins, representing the Motion Picture Association, we submitted comments in October that spoke a lot about the abuse of dominance standard, and also attached for your benefit paper that the American Bar Association antitrust section had written about the New York manifestation of that proposal. The antitrust section, Cheryl and I are both members. It's the top couple thousand antitrust lawyers in the United States, and so I give its views a lot of weight. But if you want something to look at, I think they did a really nice job of analyzing the New York bill, which the MPA opposed. I think where Commissioner King was going is a better place. I would urge you to not talk about abuse of dominance. It's a loaded political term. First thing I think of is the New York bill. Again, unsuccessful 5 years in a row. Why carry that baggage? Also, I have a lot of respect for staff and the consultant, but if you really want to look at that standard, we've been talking about Europe and Canada because those are places we like, but it's the standard in places where we have a lot of trouble too. You need to look at what the state administration of market regulation does with it in China, what other countries do. If you really want to do a robust job, you got to do a lot of international research, a lot of expense. That would be difficult, and I'd urge you just not to do that. I think Commissioner King's modification is the better approach. Thank you.
Thank you. And I believe we have a two virtual commentators. Our first one is Robert Harrell.
And please limit your comments to the motion that's on the table. Identify yourself and your organization, and please keep your comments brief as we still have a lot to get through.
Yeah, thank you. This is Robert Harrell, Executive Director of the Consumer Federation of California again. I'll be brief. I know that you've had a lengthy conversation just about this sort of piece of it. We support the modified motion here. We think it's important that the commission continue to look at this issue. And we are share some of the concerns about specific potential results, but I think the motion, as I understand its friendly modifications agreed to by Assemblymember Kalra, is to pursue this and explore different options within the abuse of dominance realm. We think that's a worthwhile endeavor and an important one, and so therefore we support the motion. Thank you.
Thank you. And our second commentator,
Ben Golombek.
Hi, Ben Golombek on behalf of the California Chamber of Commerce once again, and while we appreciate.
can you please speak up a little bit louder? We can hear you, but it's difficult to hear.
Sure. While we appreciate Commissioner King's modification, we still disagree with moving forward with the motion. We want to flag that because we haven't heard it discussed yet, that the Single Firm Conduct Expert Working Group explicitly rejected adopting any abusive dominance standard. And this was the experts that the commission staff themselves recruited. And so we think this is a serious failing in terms of their recommendation. Claiming that the abuse of dominance is necessary because existing Sherman Act Section 2 and California state laws have been ineffective, the staff ignores that many successful cases have been brought by both government agencies and private plaintiffs under the current laws, including against a number of quote unquote big tech companies such as Apple and others. And whether we call it abuse of dominance or misuse of market power, These are new legal terms that have never been interpreted by the courts, and the sheer novelty of this regime will bring great uncertainty as to where the line is between lawful and unlawful conduct, which is the precise reason that the commission's own working group rejected the abusive dominance approach. And finally, all of this is against the backdrop that there's no showing of an actual need for an amendment or a study of what the impact will actually be, which dramatically threatens innovation and aggressive competition in the California economy. Thank you.
Thank you. Do we have any virtual? Yes, third.
We have Lucy Chinkazian.
Yes, Lucy Chinkazian, counsel at CJAC. We also do not support the motion. We urge this commission to give strong consideration to the impacts this proposal would have on California's civil liability system, which is already viewed as one of the most burdensome in the country by business. Thank you.
Masri.
This is Mona Master, Economic Security California. We concur with Robert Harrell's comments, and we recommend, we urge the staff to move forward on the amended motion. Thank you.
All right, so we will call the roll.
Commissioner B?
Aye.
Senator Blake Spear is not present. Commissioner Carrillo?
As amended, aye.
Commissioner Carrion?
Aye.
Commissioner Hebner, I do not see him present, so I will move to Commissioner Jenkins.
Aye.
Assemblymember Calra.
Aye.
Commissioner King.
Aye.
Commissioner Simpson.
No.
No, okay. Okay, no. And I
The
think
motion
we're,
passes.
yeah, the motion passes, and I think we're on to the next one.
Yes.
Could we take 5?
Take 5 minutes.
If everyone's fine with a 5-minute break, that's great. So
Maybe
we
10.
why don't we just come back at 3 o'clock on the dot? All right,
Yes.
so. All right, thank you, everyone. We are coming back from a short break. It's 3 p.m. today. We continue now to our next section.
Yes, so another question that ACR 95 asked the commission to look at is whether the law should be revised in the context of technology companies, et cetera. So we did look at that. We did have an expert working group and many public comments that looked at the unprecedented footprint of digital, very large digital platforms, many of which are headquartered or have a substantial presence in California. We noted that one of the legislation that the ACR asked us to look at, Calera, avoided big tech specific provisions. And when the staff was considering everything we've heard and the reports from our experts, we came to the recommendation to the commission that the commission not entertain specific antitrust laws targeted at big tech, and instead recommends ensuring that any proposed antitrust language is drafted sufficiently broad and flexible enough to encompass big tech as well as other industries. We think that meets the charge of ACR 95, and so that's a pretty brief summary. I will turn it back to you, Chair, to see if there's any questions.
All right, Vice Chair.
Yeah, I agree with the recommendation. In fact, I might make it flexible enough to encompass any industry, regardless of the industry, something like that, because there are unique things to big pharma, there's unique things to media, there's unique things to agriculture. And so it ought to be flexible enough. It's the behavior that we seem are concerned about anti-competitive behavior, not the nature of the firm that's undertaking it, so. I would concur with the staff.
Commissioner Carrillo?
I agree with my friend Rick, and I would move this portion of the memo.
Second.
Right. Any additional comments? Assembly Member Kalra?
Thank you. Yeah, I also support this recommendation. I just have one question about it because as was just mentioned, you know, there are a number of different industries. Obviously, I'm in agreement that this should be sufficiently broad enough as mentioned in the recommendation, but it also says inflexible enough. And so the question is, would it still, and as the analysis is done and brought to us, would as broad as it should be, there are elements of certain industries that are just different from one another that may not, and I'm not speaking specific to tech or ag or pharma, but each of them are unique as well. And so I would be interested in knowing, as the analysis is done, with the understanding that I do support this recommendation, that if there is something unique that comes up that may capture a certain aspect of an industry that doesn't necessarily apply to others, it would be good to know that. And so I don't know if that's something that the staff would incorporate into the analysis aspect, even if it's not in an ultimate recommendation. But I just a question for staff. Again, I support the motion on the table and we'll be voting for it, but just, just want to get an understanding of how, as you make it broad to capture every industry, is there still an ability to have a little bit of nuance to at least have a conversation in the analysis about where you might identify a nuance that makes sense regarding a specific aspect of an industry?
Yes, and that will be part of the analysis going forward. I think we heard from a particular industry today saying, well, you need to consider that we have some unique features. So we will look at that.
Thank you.
Commissioner Carrillo?
Yeah, the Assembly member makes a good point that it came up today in the public comment, and it's also in some of the written comments we received that we're essentially going to wind up approaching this kind of in the reverse, rather than saying big tech gets one set of rules and pharma gets another set of rules, and I don't know, crab fishing gets another one, whatever. Like, we're doing it the other way around. We're establishing very broad principles from which we can do specific carve-outs if we need to accommodate whatever unique features a particular industry has. Like, for example, things that are already protected under other areas of law and guarantee exclusivity for a period of time, like copyright, patent, and other forms of intellectual property. Like that might well, as the staff looks at this, those things might require their own specific carve out, and maybe there's others I'm not thinking of. So I saw that in the public comment. I agree that's a potential concern. If it's not already carved out by existing law, we may wind up having to do that. But with that thought in mind, I think we can do this.
Any additional commissioner comments or questions? All right, we'll move forward to public comment. Are there any in-person commentators? I see none. We have 2 virtual.
Yeah, Robert Harrell.
Mr. Harrell?
Yes, thank you, Madam Chair. We support the recommendation here and really appreciate the thoughtful commentary and back and forth by Assemblymember Kalra and Commissioner Carrillo about this. Oftentimes this winds up being sort of a including but not limited to. When you look at sort of lists of behaviors, there are certain things that are unique, as Commissioner Carrillo pointed out. There also are, you have to think about other laws and protections or violations that may occur. I would just note, and I haven't used this example yet, and because I've been trying to keep everything very brief. If you look at the federal DOJ lawsuit against what we believe very strongly is the Live Nation Ticketmaster monopoly in that space, I would note that's a lawsuit that is federal DOJ plus 39 of the 50 states plus DC. So the list is way shorter of those jurisdictions that aren't alleging this: purple, blue, red, all states, almost all. That could not have been filed by the California AG. At least most of it couldn't have been because of the lack of the single firm conduct provision in Cartwright, which you all have discussed previously. There's a little piece of it that deals with collusive behavior, but it's a minority. And there are different unique things to different industries. And so I think it's completely consistent, the motion that you have on the table, with the approach that you want the staff to take to continue this work. And finally, per Assemblymember Culver's comment of a while ago, you know, time is of the essence here. The legislature, groups like ours and others are not going to be waiting forever. There's a need here to take action. And so we support this recommendation and urge the commission to move expeditiously to explore these areas. Thank you.
Thank you.
Next is Ben Gollenbeck. Ben?
Yes, good afternoon again, Ben Gollenbeck from the California Chamber of Commerce. In a not surprising result, we disagree with the recommendation. Calling out sort of quote unquote big tech is really a political term of art. I think it ignores that the tech sector accounts for almost 20% of California's gross regional product, which is, I believe, about $620 billion a year. It accounts for about $56 billion in state tax revenue. And when you look at the sort of, sort of ripple effect and broad positive impact of the tech sector in terms of business to business interactions and personal consumption, you're looking at almost a $1 trillion impact to California and 4.2 million jobs, which is 20% of all jobs statewide. The proposal from the staff here would go a long way towards stifling innovation. And certainly when you're looking at growing sectors like the artificial intelligence community, which is essentially keeping downtown San Francisco afloat right now from a real estate perspective, it is going to have a profound harm on California's upward economic development trajectory. I also just point out here, and I know I mentioned this a little earlier, that basically every company that is tagged with the term quote unquote big tech has faced an antitrust inquiry over the last 10 years on the federal level by both President Trump, President Biden, and President Obama's DOJs from both parties. And so there's no shortcoming in terms of oversight of the tech community. And this would have a chilling impact on their willingness to expand here in California. Thank you.
So, Mr. Gollenbeck, still there?
Mr. Gollenbeck, I believe there's a question or comment back to you by our vice chair. Can you please unmute yourself?
Still there?
Ben Gollenbeck, there's a question from the commissioner for you.
Can you hear me? You guys,
Yes.
did you? Okay, sorry.
No,
You
I
had to
just wanna
unmute
see-
me. I couldn't unmute myself.
I think you might like this recommendation then, because the staff recommendation is not to pursue specific laws on tech. So do we have? finally have a
I also
recommendation?
heard you saying you were against this. You should be
Yeah,
for
you
this,
said,
right?
you said you were opposed to the staff recommendation, but the staff recommendation is not to have specific laws for tech.
Yeah, that is what I was saying there, which was that there should not be specific, I understand. Sorry, can we be clear then on what the proposed, because there was a change to the recommendation, right? That's what we were talking about?
No, the
Recommendation
previous
is not
one we
changed.
changed.
The recommendation is that we not recommends against big tech specific antitrust laws.
And my motion is that we adopt that.
Yeah, right. And a
Sorry,
motion
I
to
thought
adopt-
that you were recommending to change the staff
No,
recommendation.
no, I like this one.
Nope.
Okay,
Adopt-
well, all of my comments about the great impact of the tech community still stand,
It
so.
worked. It
Yes,
worked.
we appreciate that.
It worked. Good job.
And there's one more comment, sure.
Great.
Dylan Hoffman?
Hello, Dylan Hoffman on behalf of TechNet. Want to echo many of the comments from the Cal Chamber espousing the benefits of the tech sector, appreciate the recommendation from the commission. Appreciate the work of the folks, but in support of avoiding additional antitrust laws on big tech. I think it would have a dramatically negative impact on the state. So appreciate the direction that this conversation is heading. Thank you.
Commissioner King?
Yeah, it sounds like from the comments that this will pass, and hopefully as a part of it passing is that we just stop using words big tech. I think that'll naturally follow if we pass this. But the whole way this whole study has been framed is it's like a wrestling match, state of California versus big tech. And I just want to avoid that phrase. Extraordinarily large companies, I don't know, but there has to be another euphemism, and certainly nothing with capital letters. It reminds me of how an oil company I have children, so an oil company that was the hero in Cars 1 became Big Oil in Cars 2, and you thought of oil companies very differently the moment you capitalize those words.
Madam Chair, was there a second?
Yes, there was from Vice Chair Simpson. So at this time, there is no additional public comment. So if we can have a roll call.
Sure. Commissioner B?
Aye.
Commissioner Carrillo?
Aye.
Commissioner Carrion?
Aye.
Commissioner Jenkins, and I'm skipping those who weren't present.
Aye.
Commissioner Jenkins, aye. Assemblymember Calra?
Aye.
Commissioner King?
Aye.
And Commissioner Simpson?
Aye.
The motion passes.
Okay.
Now moving on to our next section on merger law.
Okay, so merger law was also featured in ACR 95. So as you'll recall, we did have an expert report on merger law. So the question before the commission is, should California have its own mergers law? As we recognize throughout all the public comment and expert studies and all that, mergers and acquisitions can be powerful engines for innovation and have real consumer benefits. Sometimes they can negatively impact the economy by reducing competition. The California Attorney General, like other states' attorney generals, may act alone or partner with federal agencies to challenge a merger affecting California. But the AG Attorney General must generally do so in federal court under Section 7 of the Clayton Act. And I'm just moving forward a little bit. As we saw in the feedback we got, there have been arguments that practitioners or that California should not be reliant on the federal merger regime and have the legal power to police competitions and mergers within California's own borders. Even if California state merger law simply copied federal merger law, the benefits could be significant. It could also allow state court judges to adjudicate challenges. Right now, it's happening in federal court. And state court judges may be more familiar with state law and interests and bring a state-centric perspective to antitrust. An effective state merger regime would require prompt notification of any merger affecting the state. And we note that there are some requirements in federal law related to companies filing pre-merger notifications. We would also like to acknowledge that the Uniform Law Commission's recommendation on antitrust or draft legislation on antitrust pre-merger notification has been introduced by Senator Umberg as SB 25. Any analysis that the staff would provide on this issue would include a discussion of SB 25. And so with that said, the staff recommendation is that California adopt its own merger approval and pre-merger notification laws. I'll turn it back to you, Chair.
Yes.
For questions and
Yes,
comments.
Vice Chair?
Yeah, maybe a question and then a comment. First of all, when you say adopt its own merger Oh, approval and pre-merger notifications, okay. So this could be costly, is my understanding, that it, for California to evaluate mergers doesn't come without cost, or DOJ, I assume. I think at a minimum, we ought to embrace the Uniform Law Commission proposal on sharing the information. And I don't, I mean, ultimately, the legislature would have to decide in terms of something that is costly, and I'd be at least cautious about imposing fees. I guess the feds do impose fees, and I don't know whether we ought to do that as a state or not in our merger thing. That would be something that could be problematic. So anyway, I'm okay moving forward. I just think that this feels to me that we ought to be a little more cautious on how far we go on this one.
Commissioner King? Oh, I believe Assembly Member Kalra. Thank you. Go ahead.
Yeah, I agree that this is a big endeavor. It certainly is something that we should proceed cautiously with, but as indicated by staff, like we've already seen, the trend has been that the federal courts have made it more and more difficult to successfully challenge mergers. I don't think anyone would predict that that trend is going to go anywhere but on the same trajectory of making it more and more difficult. In terms of, you know, what the costs associated and what have you, yeah, absolutely, that's going to be something that will be vigorously debated and should be through the legislative process. But that being said, in addition to what I believe would be the need for us to have our own standards that we can bring toward in our own courts, rather than relying on federal support, the helping to inform my counterpart in the Senate, the chair of the judiciary there, Umberg's bill, would be an added benefit of delving further into our state having its own merger laws. So I absolutely think that this is more necessary than ever, based upon our current, the current situation we're in. And I know that, you know, folks might feel uncomfortable me bringing up some things that may be political, but it's it's hard to describe how tense it is right now in the legislature because of what's happening in DC. That's just a reality. When they're threatening to investigate and prosecute lawmakers for protecting our residents. I mean, it's a very difficult time right now. And my number one priority is protecting Californians and making sure that our laws, do everything they can to protect all Californians. And that is sometimes going to mean in general, no matter who's in the White House or who's in Congress, that we have to stand up for our state against any federal actions. But the reality is that right now more than ever, we do need to move with urgency. And I think this is one area that I definitely trust a partnership with our Attorney General in terms of using whatever information we're able to give the Attorney General's office, but also the legislature can very much benefit from the work that this commission can do to advise us if this is a path that we want to go down, how to do it cautiously, how to do it maybe expeditiously, but thoughtfully, but also to consider the costs involved as well. So I'd like to make a motion to accept the staff recommendation 6 on merger laws.
Thank you. Commissioner King?
Yeah, addressing Commissioner Simpson's comments about cost. Yes, it is costly, but that's one of the reasons why we need it, because the federal agencies are out of money to do this. From an article in the California Lawyers Association Antitrust and Unfair Competition Law publication by Abel Garcia here, he points out that less than 2% of mergers are getting any scrutiny because the feds don't have the money. And with this new administration, I know that we're writing law for the long term, but for the next 4 years at least, there will be little to no oversight of mergers. And we're an important state with very large companies, and you know, in theory, all these large companies could all merge together and be the largest company in the history of the universe. So we have interests in doing our own merger law when the federal situation is likely to almost eliminate merger oversight.
Are there any additional comments or questions? Commissioner Jenkins?
Yes, I just wanted to add my support for this recommendation. Wanted to also just clarify, I believe what the director said was that we would be, if this recommendation is adopted, that the staff would be providing more analysis related to SB 25, the Senator Umberg bill that deals with, specifically with the pre-merger notification issue.
Thank you. Now we'll move forward. Is there a motion? There's a motion. Is there a second? We have a second from Vice Chair Simpson. We'll now open it up to public comment. Do we have in person? You are not chilled. And that's a good thing. That's what we want.
My children tell me I'm also not chill.
There you go.
Which is a different comment. So thank you, Madam Chair.
Of course. Thank you for being here.
So I'm here as a representative of your sister commission, the California Commission on Uniform State Law, and its national affiliate, the Uniform Law Commission. I wanted to give you an update of what we're doing and explain why we're doing it, hopefully so that we can be cooperative and supportive. So I was the chair of, the way our process works is we have a study committee, and then it recommends the drafting committee be formed, and the drafting committee drafts the laws, and then we seek their enactment. And so the study committee recommended that a pre-merger notification law be drafted. I was chosen as the chairman of the drafting committee. The way our process works is we try to bring in as many stakeholders as possible. So the Federal Trade Commission under Lena Khan, the Department of Justice Antitrust Division, 3 senior people from AG offices, including California, New York, and North Dakota, came to every meeting for 2 years. Respected our process. We had a lot of input, but at the same time, I recognize I can't run around to 50 states and pass something without calling up the Chamber of Commerce. That's naive. So I went personally to see 12 state chambers of commerce, including the Cal Chamber, and also the United States Chamber of Commerce. And we took their input. What the bill does is the AGs get notice of the deals that they don't get today. The AGs get the HSR filings that they don't get today, absent finding out about it secondhand, issuing a subpoena, making somebody like Cheryl do a lot of extra work. The other side might litigate, spend a bunch of money. It's the waste. So they get that information. The business community was very clear with me. They wanted 2 things. Number one, this information has to be maintained as confidential. It's got a lot of trade secrets. All sorts of problems occur if it gets spread out, securities law violations, because you know what somebody's going to do in the future. And then 2, they refuse to pay additional fees. So at the federal level, the fee structure today starts at a minimum of $30,000. It can go up to about $2.5 million in fees that go to the federal government. Their nightmare scenario is I've got a law in 50 states and I have to pay 50 AGs plus, DC and Puerto Rico. That's really going to unnecessarily burden the process. So, we agreed to have no fees and confidentiality in exchange for them turning over data they don't turn over today. And so this, we followed our multi-year process. It went to a vote of the states in the summer. It passed 45-1. The California delegation voted unanimously to support the bill. The only opponent was the state of Alabama. I'm not quite sure why, but we don't, in California, we typically don't follow Alabama. And Senator Umberg, the Judiciary Committee Chair, agreed to be the author. He introduced the bill early in December. The California Commission on Uniform State Law is the sponsor. This bill is moving in other states too. I testified on it in Washington State earlier this week. Senate Majority Leader's a big fan, so we're moving throughout the country. Here's what we hope to achieve. And this is based on input we got from all these enforcers, is to us, it doesn't make any sense to duplicate efforts. So if the FTC wants to do something, then it should talk to the states should talk to each other. California taxpayers should not be paying to do an economic study on a merger when the taxpayers in Washington State are doing the exact same thing. It didn't make any sense to us. And so, the need we're trying to solve is we're trying to get rid of this duplication. We're trying to get the states to work more closely together and also work with the federal government. The law specifically provides that all those parties that have agreed to the confidentiality can share. They can share their learning, and they can come up with a decision. And just as an aside, I've heard the 2% figure mentioned a couple times. There's a lot of reasons for that. So the federal government gets 2,000 filings. Yes, most of them go through. But there's a lot of inferences you can draw from that. One is, well, maybe they don't have enough money, or maybe they're actually competitive deals that don't raise problems, and the federal government's not bailing on its obligations. I think that's a very complicated thing to look at, and it's a mistake to just assume that if we poured more money into it, that like 100% of those deals would get challenged. I don't think that's a reasonable inference. But in any event, this is where we are. My request is, if any way you can support SB 25, we would appreciate it. We think it's complementary to what you're trying to do overall. And it can't be California alone. To have the cooperation, you need the other 49 states. So that's our goal and our vision. And we hope that you can support us in any way appropriate.
Thank you.
Does assuming SB 25 goes forward, does that have its own implications for California adopting its own merger approval process?
So this is a supplement to whatever else you all might recommend and the legislature might pass.
Okay, so this would be, this could be information that's used by the State Department of Justice if it was going to do its own, had its own approval obligation.
Right. Yeah, this is supplemental.
Okay, and does the passage of SB 25 presume that the state of California wouldn't add more fees to help pay for DOJ doing its own thing? I mean, it doesn't say it presumably, but is that, would that be implied?
So the only thing the act specifically says is you can't charge a fee for the mere receipt of the information you wouldn't have had without the act in the first place. There are other, there's other ways to get resources for these matters, and if they're important, we should,
budget could.
Yeah, we should resource them if they're important. I think the one thing where there might be some tension is, our vision is cooperation and efficiency. We didn't envision, California leads the way, California does all the work, California taxpayers foot all the bill. That didn't make sense to us. Like, to be pretty direct with you, why not leverage the other states? Why not take advantage of the work they're doing so that our taxpayers don't have to pay for it? We should all work together. That's the the theory and the vision. So to the extent, if you all went in a direction of oh, California needs a big new agency, California is gonna take control because, for whatever reason, the other states, the federal government are inadequate. That sort of differs from the vision, because this is like we're stronger together vision.
And if California were to have a law that required its approval, how would that interact with federal approval or not approval?
So the beauty of this actually would, when I was a very, very young person interested in antitrust, even before I met Cheryl, way back in the early 90s. I was a law clerk at the AG's office doing research on the American Stores case, which was a state's successful challenge to the Lucky Alpha Beta merger. So the federal law provides that the states can enforce it and the federal government can enforce it. We're both equals in that regard. In the case I'm talking about, some of us remember Lucky and Alpha Beta. So there was a merger and the parent was American Stores, and President Reagan's FTC approved the deal. And we in California didn't believe that was adequate. It didn't address the competition concerns in our state. And so we brought our own action, which was fine. And the other side challenged it all the way to the Supreme Court, which ruled unanimously in our favor that, yes, you can move forward with this. You can get injunctive relief. It was actually quite a big victory for the state. So we, whatever we do in California will be supplementary to whatever the federal government does. It's independent. We have the rights to pursue this ourselves.
If we had our own merger approval law, California challenging something that had been already okayed at the federal level would go to state court.
Yeah, if we had our own, like today, these all go to federal court because it's the Clayton Act of federal law. But if we had a state specific one, then it would flow through the state system.
These are all lawyers. I'm not, so
No, it's
still learning.
Those are good questions. I think one of the things we have to be mindful of is, other states will act too. And so this is just my personal view now, 50 different flavors of the Clayton Act. That's good for lawyers, we'll make a lot more money, but I don't think that's good for the country. And so this isn't happening in a vacuum. So we just have to be careful about how we do that. And then the other thing that we looked at and decided not to move on at the commission was in New York, for example, they had a rule that said any deal that's at 1/10 of the federal threshold has to be reported. So that was, at the time, you'd have to report any deal over $9.2 million, which is very, very small. And that would send in like tens and tens of thousands of additional things into Albany. It didn't pass, but you just got to be mindful of, what are we doing, what's best for our state, and what happens to the business community if all the other states do something and it's too many flowers blooming.
Thank you.
Great. Any other questions? Very good. Thank you all.
Additional public comment?
Yes, we have three right now. First is Michael Strumwasser.
Can you hear me?
Yes.
Great, thank you. Michael Strumwasser, representing the Western States Council of the UFCW. And perhaps I should add, in light of the previous witnesses' comments, I was also, I'm a former deputy and then special assistant attorney general and was a counsel of record in the American Stores case. So if you have any questions, feel free to test my memory. And also apropos the conversation that has already taken place, I think it's very important that we not use the term approve a merger. The Attorney General, neither the Attorney General nor private litigants approve or disapprove the merger. This is a question of prosecutorial discretion, and it's an important question because even without there any approval, you will find people saying, "Oh, this case was approved by." I think some of the comments you received said that that various mergers and transactions were approved by the state or the attorney general. The attorney general did was they said, "We've only got so much resources. We've got so many wonderful targets. We choose not to stop this merger. We're not approving it." And nothing that this commission does should cultivate the notion that there is an approval stamp attached to an unprosecuted merger. This also in response to the previous witness, we oppose California's adoption of the uniform law as he described it. Last March 14th, we submitted a letter to the commission with a large number of suggestions and recommendations, one of which was an analysis of funding mechanisms and procedural matters. And I will simply commend that to your attention. But basically, the notion is that you can very easily give the Attorney General of California the right to the ability to take what he already has, which is the ability to get on confidential basis the HSR document. You can also find other funding mechanisms. It's easy for a witness in front of you to say, "Oh, you can find the necessary votes, the necessary dollars rather, to prosecute these cases." As has already been said, these are very expensive cases to prosecute. I would not presume to talk today about what method should be used after 45 years of voters' initiatives about what kinds of money can be collected and used. It's an important and difficult question. It should be studied thoroughly by the staff, but the uniform law is not of any help to you. That said, I have two major points I would like to make, and then I'm going to ask another witness, Andrea Zinder, who is the president of Local 324, to elaborate on her own time. But I want to make 2 points about a California merger law. First of all, the opposition that you have received today, and especially in the written material, starts from a false assumption, and that is that only very large companies can innovate. If you don't let them get really, really big, they won't innovate. Won't innovate, and that is logically, empirically, historically false. It is true that innovation takes money, often large amounts of money. It is false that the best way to get innovation money is by finding rich companies to spend their money in innovation. That is ahistorical. If you think about where innovation has occurred historically, IBM was dominant. They didn't come up with the personal computer. That was a couple of guys in the garage. The personal cell phones were not invented by AT&T. It was invented by a couple of kids in California. Social media was not invented by Microsoft. They were the dominant software people. It was invented by some guys in a college dorm. And Amazon wasn't invented by Sears Roebuck or Montgomery Ward. It was invented by disruptors, a financial analyst who had never sold anything at retail in his life, who came up with a better logistical model. So the notion that you got to throw dollars at big companies so they'll maybe find in their kindness help us is just not historically borne out, and is also not logical. We have a well-developed venture capital industry in the United States, and there's a well-developed pattern for how you get venture capital. And it is not the chairman of the board saying, yeah, I think we're really good at this. I think we ought to spend some money. It's hard-headed guys who have lumps of money that they want to invest, asking, do you have a good idea? Not only whether you have a good idea, do you know how to run a company? Do you have a business plan? And under those rigorous circumstances, they decide whether or not a good idea is cultivated and becomes a product. So this whole notion is false.
Thank you so much for your comment. I'm gonna, it's time now. It's 5 minutes. If there's any want to finish your round off your last sentence, please do
Well,
so.
yeah, let me just say, the reason why I'm asking you to listen to Andrea Zinder is because it illustrates well the other fallacy of the industry's defenses here, and that is highly speculative assumptions that never materialize until it's too late to avoid them. And with that, I will rest. Thank you.
Thank you. That isn't true.
Next is Robert Harrell.
Thank you. Good afternoon. I'll just note that this is an important area for exploration. As I understand the motion, and it feels like a lifetime ago, the motion is to move forward and explore this. Is that correct, Madam Chair?
The motion is based on the staff recommendation to propose that California adopt its own merger approval and pre-merger notification laws.
Yeah, I mean, thank you. This is a supportable motion, and then I'll cede back the remainder of my time so you can hear from other folks. Thank you.
Thank you.
Andrea Zinder.
Hi, good afternoon, commissioners. Thank you for this time. I'm Andrea Zinder. I'm the president of UFCW Local 324, which is in Orange County, California. Also represents South Los Angeles County. And I have been in this line of work. I'm primarily a negotiator, and I've been in this line of work now for over 40 years. So I have negotiated contracts with the grocery industry when there were many grocery companies competing, right up to the time now where we almost only had one big company competing for our members' labor. I had the privilege of testifying in the federal case in August, before as a witness for the FTC, and I just want to explain how devastating consolidation is to workers and their wage power, their buying power. When we had many companies in Southern California, we had much higher wages. As the number of companies declined, our bargaining power and workers' ability to leverage companies gradually declined. And I would say one of the hardest situations in my entire career was in 2015 when Albertsons and Safeway merged. And when that happened, they found a company in order to satisfy the regulators. They found a company to purchase stores to maintain competition. They sold the stores to a company called Hagen, and Hagen represented itself as, you know, a good employer, a good company for consumers. For our members, they accepted the existing contracts. They accepted the existing pensions. Employees kept their seniority. So we thought this was, you know, a viable solution to the reduction of companies, that this was going to maintain the competitive environment for workers. And within 5 months, Hagen went bankrupt. And, you know, looking back on it, we know that Hagen never was set up or expected to succeed. For workers, grocery workers with a lot of time in the industry, a lot of experience, they found themselves suddenly without a job. And the devastation on the community, workers, families, it was unimaginable. We heard stories from members who we were making a middle-class income, supporting a family suddenly without a home, moving in with family members, with their children, unable to, you know, figure out what to do next. And having that in our, you know, mind now, we were very, very skeptical, extremely skeptical when Kroger announced that it was going to divest stores to a company called C&S, which had even less ability, we thought, to compete. So we have been successful over the years in leveraging companies against one another. When you have more companies and you're in bargaining, you have an opportunity to try to get a contract with one of the companies or two of the companies, and then the other companies are left to sign on or to be isolated. When you have one or two companies, it makes it much harder. Maintaining at least two major companies in Southern California or in California and actually nationally was so important. And that is why we were very pleased when the federal judge ruled against this merger or enjoined the merger.
Now, Ms. Zinder, you're almost out of time, and the issue here is the current motion, so it'd be great to hear expressly from you whether you agree with the motion that California adopt its own approval and pre-merger notification laws. I have a feeling of where you're gonna say, but it would be helpful to get it clearly for the record.
Okay. For the record, representing the UFCW Western States Council, we urge the commission to move forward on drafting amendments to California's antitrust law. We support the motion.
Thank you.
Thank you for your time.
Thank you.
Next, we have Ben Gollenbeck. You can unmute yourself at this point.
Okay, can you hear me now?
Yes.
Okay, great. Sorry. Ben Gollenbeck with the California Chamber of Commerce. Again, on this one, we do disagree with moving forward the motion. The staff's recommendation to create a California merger and acquisitions regimes is a radical departure from today's antitrust environment. The question the commission, we believe, should be asking is whether the creation of a California-specific merger review regime is necessary and whether such a regime would, on balance, be good for California. The clear answer to both questions is no. First, state regulators, in particular the California Attorney General, have repeatedly used federal law to challenge mergers and acquisitions that may negatively affect competition in their state. Moreover, as the commission is aware, and we've talked about, the ULC passed their State Pre-Merger Notification Act. I don't need to go into that any further, but we agree with the direction of those recommendations. Second, creating a California-specific merger review regime will increase cost, complexity, and uncertainty associated with transaction and risks, chilling pro-competitive or competitively neutral transactions. In fact, the Mergers and Acquisitions Working Group report that the commission's experts put together recognize that, quote, businesses would bear the costs of another set of merger laws with a California merger control process that overlaps with the federal process because it would, quote, allow California judges to develop legal standards that differ from the federal standards, and that, quote, California courts would produce different merger decisions even with an identically worded statute. It's critical to keep in mind that most mergers and acquisitions are pro-competitive and are an important part of a healthy economy. Diverging merger control processes and decisions will discourage these transactions through increased costs and uncertainty, all of which is unnecessary given existing federal law. Finally, I'll just note that the number of challenges that was mentioned earlier about what's going on with the change in federal administration, and I'll just note that the number of court proceedings to attempt to block mergers in the last 2 years of the Obama administration, there were 13 such court proceedings. In the last 2 years of the first Trump administration, it was 15. So there's no evidence that there will not be oversight of mergers and acquisitions during the current administration. And lastly, as a note of personal privilege, as a former AT&T employee, I would encourage Mr. Strumwasser to go back and look because the cell phone was in fact invented by an engineer working at Bell Labs, which is part of AT&T. Thank you very much.
Thank you. Do we have additional commentators?
One more, Mona Masri.
Thank you.
Hello, I don't want to take any time, but Mona Master, Economic Security California, just to say that we also recommend adopting California's own pre-merger and approval standards for its own pre-merger law. Thank you.
Thank you.
And there is one more,
All right.
Natalie Schumann.
Ms. Schumann?
Hi there, can you hear me?
Yes, we can. Thank you.
Hi, my name is Natalie Schumann, and I'm speaking on behalf of the Writers Guild of America West. We're a labor union that represents thousands of writers of movies, television, and streaming series in California's vital media and entertainment industry. And our members experience the harms of unchecked consolidation firsthand, and we've watched as decades of consolidation have transformed the industry into one dominated by just a handful of companies who abuse their position of dominance with workers, consumers, competitors, and threaten to consolidate even further today. So with its recommendations, the Commission has really the opportunity to push back against this further consolidation, which is looking more and more likely under the current Trump administration. And so we encourage the Commission to pursue, increased enforcement against harmful mergers and abuses of dominance, for you guys to recommend conducting retrospectives and market investigations, and empower the state's antitrust enforcers with clear jurisdiction to regulate anti-competitive behavior and mergers. So yes, we think that we support the motion, and in general think the staff's initial recommendations are a great start toward that end. And we'd also just remind the Commission about our submission of comments and research into the record back in June of last year, and hope you'll consider those a resource as this process moves forward. Thank you.
Thank you. I believe we have an in-person commentator. If you can come to the podium.
I'm sorry, there is one more after.
We can go ahead. Why don't you go ahead since you're already at the podium?
Great, thank you. On behalf of the Motion Picture Association, I want to respond to my friend at the Writers Guild. We actually have quite a competitive market. The MPA alone has 7 members who are vigorous competitors, and they're always taking market share away from each other, which is exactly what they're supposed to do. Maybe one will have a higher level one year and then somebody else will take it away. Why? Well, because they make better movies that year. Simple. And this is the ecosystem we want. We also have a very strong independent sector that competes pretty vigorously. And we prepared an economic study for you all, which we submitted about the industry because we strongly disagreed with the concentration group's conclusions about our sector. So we wanted to show it to you. So that does show the pricing, and it also includes what people are getting paid. It doesn't single out the writers, but it shows that the wages are competitive in the sector. So I encourage you to take a look at that. The other thing is, when you go through this process, you have to, in the exploration, you need to think about how far things go. So I'll just give you one example and then I'll rest. Is in New York, the initial bill reduced the level of reportable transaction by an order of magnitude. So at the time it was 92 million and it went to 9.2. It included acquisitions. So when one of my members goes to an author to get the rights, exclusive rights to make a movie, they tend to pay a lot of money. These people are not underpaid. One of my members actually said, well, Dan, we wouldn't roll out of bed for that transaction unless we're paying at least 10 million. But all of a sudden that becomes a reportable transaction. So if I want to make a movie out of a book, I have to go to the Attorney General's office and get permission. Imagine, I could go to the one in California and I get a different result in Texas. Is that how we want our content produced? Just, be mindful of it's complicated space. And so as you walk through it, be mindful. And this is a real example. This happened in New York. It's one of the reasons we opposed that bill. So thank you very much.
To clarify, are you for or against the pending motion?
To explore?
It's to adopt its own merger approval and pre-merger notification law.
That's
If you have no answer, that's fine. But that's the issue
It's-
we're dealing with right now.
So yeah, we addressed this issue in our letter in October. We, and that position hasn't changed. We don't believe every state should have its own different version of the Clayton Act. We're opposed to that. We think the Clayton Act is the right way to deal with this. I should have given Mr. Strumwasser credit for winning the case. I was just a law clerk at the time. Could barely find the law library, so credit to him. But it does show, all these examples we heard about show the system works. We won that case. The other big supermarket merger, the states won that case. The other case that was mentioned by the other speaker, again, plaintiffs win, plaintiffs win. It's like, it does work. It works in my sector. There was a proposed book merger that Paramount Global was involved in. Again, the plaintiffs won. So they win, we've got competent people. They do a good job. They win plenty of cases. We don't think that needs to be changed. So thank you, unless.
It was more generic, and maybe it was to Cheryl or.
Oh, okay. All right. I just wanted to make
Yeah.
sure if it wasn't specific to this comment.
Okay, very good. Thank you.
Great, thank you.
And somebody else.
We have one person virtually, and then we have another in-person commentator. So let's go ahead and hear from our virtual commentator first.
Lucy Shikenzian.
Thank you. Yes, Lucy Chinkazian at CJAC. We do not support the motion, and we ask you to please refer to our letter submitted on August 2nd of last year for more details as to why. Thank you.
Thank you.
Ben O'Brien, thanks for giving me the opportunity to speak again to the commissioners. We also do not support the motion, primarily for some reasons I stated before. Our life science industry, again, I'm representing California Life Sciences, is very dynamic and really involves a lot of mergers and pro-competitive actions that we feel could be stifled by this type of proposal. Again, these kind of mergers often happen with small firms, large firms, all different kinds, and any kind of slowdown could really impact patient access to needed therapies. Thank you.
Thank you. Vice Chair?
Yeah, just a generic question. Well, one is, first of all, is what's the difference between a merger and an acquisition?
It's just a form of it, but they're buying the stock as opposed to, I don't know, buying the whole business.
Okay. All right, so it's functionally the same.
Well, you could be acquiring assets.
Yeah, okay.
As opposed to a whole business, so.
The other thing is, in the staff recommendation, it says merger approval. Not being knowledgeable about this, does that mean that if someone notifies currently the US Justice Department about a proposed merger, they can't do it unless they're approved, or they can do it unless they're challenged?
Under federal law, once they file their HSRs, the federal government has a limited period of time to investigate it and decide whether to challenge it.
Right.
If it doesn't challenge it, then it can go ahead.
It is.
And
It is
it's
a-
not, quote, approved, it simply hasn't been challenged and
Right.
it is allowed to go forward.
So there's no approval per se.
I think that was the point Mr. Strumwasser was making. It's not an approval
An approval,
process. Yeah.
Okay, yeah, I wasn't clear, because when it says merger approval, it seemed to me it may be able to say merger challenge or something like that, but.
It's a term that unfortunately we use wrongly.
Yeah, well, yeah, but you can fix that.
Right, that's what we're here to do.
Yeah, okay.
We have any more public comment? Commissioners, any other questions or comments? All right, we will move on to roll call.
Yes. Commissioner B?
Aye.
Commissioner Carrillo?
Aye.
Commissioner Carrion?
Aye.
Commissioner Huber is not here. Commissioner Jenkins?
Aye.
Assemblymember Colra?
Aye.
Commissioner King?
Aye.
And Commissioner Simpson?
Aye.
The motion passes. Let's move on to our next section.
Okay, so we might be able to get through this one, with a little help from Cheryl too. It's one of the more nuanced, questions. It has to do with mergers again. And the question is, should California adopt the lower appreciable risk standard for proof of harm in any merger review? So, again, this is an area of the law, that's largely dictated at the federal law and the standards. The evidentiary burden, standard of proof that has evolved over the year, coupled with the huge differences in resources between merging parties and the governors and the government, creates a significant challenge for governments even filing challenges to propose mergers. The federal legislation, the ACR 95 directed the commission to look at, proposed to replace the standard in federal merger law with one that prohibits mergers whose effect may be to create an appreciable risk of materially lessening competition. So it would be, I suppose the best way to describe it is a lower standard of proof that would make it easier for enforcement. So that's my summary, unless you have anything to add to that, Cheryl.
No, it represents a departure from existing federal law, which is why it was kind of singled out as a separate topic. It may be a little premature, but it was a reform suggested by Clarence, some of the commentators, to even the playing field, as some would describe it, for enforcers to more effectively challenge mergers.
So the staff recommendation is to adopt the appreciable risk standard of proof for harm in merger review for California merger law. The commission obviously can direct the staff as they see fit at this time, and it looks like somebody has a question.
So there are three commissioners. I'll just say the order now. It'll be Vice Chair Simpson first, Assembly Member Kalra, and then Commissioner Carrillo. Go ahead.
What's not clear to me is that appreciable is necessarily a lower standard than substantially will likely cause harm or something like that. I looked up in thesauruses. And those are synonym in most of those. And what I don't quite understand is that has some implication because it's different from substantially, or is it clear to everybody in court law world that appreciably is a lower standard? And if it's to be a lower standard, it seemed to me, I mean, this is like a standard of proof in, criminal law or something like that. Beyond a reasonable doubt, we used clear and convincing evidence on the CJP. More likely than not, so my instinct would be if the intent is to have something that is a lower standard than whatever substantially means, then we ought to be clear that it's a lower standard. I mean, as opposed to something that's just a different word. I don't know that it's a different word, but unless, everybody in lawyer land knows that means it's a lower standard.
I think the intent behind the suggestion is that it is a lower standard, in part because it departs from federal law. It's intended to be a lower standard, and it has an appreciation among some antitrust practitioners that it is a lower standard. The language that the Clayton Act has to require proof of harm has not changed over 50 years, but yet in interpreting it, the courts have kind of put their fingers on the scale in terms of
Yeah.
the kind and the quantum of evidence. So some believe that this change in the words will signal a departure from that stricter standard of proof.
What, but couldn't, I mean, if this was adopted by the federal law, couldn't those same courts say, oh, appreciable, that's a much higher standard?
Right.
I mean, it's different, right? That's why, I'm just wondering if we're really intending to make it give ability to challenge more mergers and acquisitions, that it ought to be something that is explicitly a lower standard as opposed to just a different word that different courts could interpret differently.
I think it's understood as a lower standard. It is a proposal in the Calera bill, the federal legislation, and it's
Which isn't
been
gonna pass.
which hasn't passed, but it's described as a reduction in the standard of
Yeah.
proof.
So I think if I could just interject a little bit, I think that's really a drafting thing that the staff could, when, if the commission wants us to move forward with that, we could recommend language that makes it clear that it's a lower standard, or not a lower standard,
Be
I'm
lower
saying this
standard
wrong.
of proof.
Yeah, because, yeah.
Now, just going into that, clarification, would the recommendation still have the same intent if we were to say, the staff recommends adopting a lower standard of proof for harm and merger review for California merger law without using the specific language? I also mirror the vice chair's concerns with the word appreciable and creating another standard of proof. So I just wanna make sure, if that were to happen, if there was to be such a motion, would that?
I think that's an excellent amendment.
Okay, all right. Well, I will make that amendment, request for amendment. But let's turn to our other commissioner, Assembly Member Kalra.
Thank you. You know, obviously, these are legal terms of art that ultimately, you know, get defined through the courts. That being said, on the surface of it, you know, I also would agree that appreciable risk would be a lower standard that may be substantially to lessen competition or tend to create a monopoly. That being said, I'm fine with the amendment, understanding that appreciable risk will be one of the potential outcomes of what that ultimate standard might be. I mean, I think ultimately our goal is to create, especially if we've already adopted recommendation 6, the merger laws. Now we have to, I think, help create some form to that in our state laws by creating a standard that does depart from not just federal law, but federal precedent that's been set over the last 75 years that has continued to move away from the original intent as indicated in the staff report. And so I think that whether it's appreciable risk, which I'm fine with, or some other terminology that staff comes up with that meets the same goal, I think that we do need to go in a direction as we're charting down a course of creating novel law for California. And again, ultimately, it's the court process, judges, appellate judges, the Supreme Court of the state, to some extent, the legislature are going to help to create some form and some definition to what are otherwise, you know, words that can be interpreted 100 different ways. And so I support the motion and appreciate the conversation on it.
And just to make sure, I'll go ahead and make the motion. I formally didn't say that, but I had made a recommendation. But I'll make a formal motion to just change the lower standard of proof for harm in merger review for California merger law.
And I'll second that.
Okay. Commissioner Carrillo?
Yes, thank you. 2 points. One is that consistent with my previous comments, staff, you had me at departure from federal law. I appreciate that appreciable risk can the comments of my colleagues expressing a little bit of concern about potential unclarity, especially as that plays itself out in the court. Fine. My initial reaction to such concerns is usually we'll just clarify it in a comment, but that's come up a few times today. So it's making me wonder if we would be better off including an omnibus comment at the beginning of whatever package of recommendations or the the first statutory provision that comes out of this, to have a general comment that says all of these changes are intended to depart from federal law, and any similarity in phraseology or concepts is coincidental and not intended to invoke federal law, something like that. Because I think that's one of the, so we have two overall purposes here within our umbrella charge. One of them is to find and fix any problems in California's antitrust law. And then two, to differentiate that California law from federal law so that we don't accidentally wind up importing something. So with that, I'm on board with this. Victor's
Thank you,
behind you.
Commissioner King.
Yeah, I appreciate that concept, but I oppose it because it's kind of a declaration that we're mavericks.
Is that a bad
someone,
thing?
what?
Is that a bad thing?
Yes, it is a bad thing because it won't pass. The gentleman from the Uniform Law Revision Commission has said Pennsylvania failed, New Jersey failed, the federal effort failed. The cards are stacked against any of the stuff passing. So that's why I've been so concerned about language, because I don't want to spend 4 years here or 3 years, it looks like, and getting nothing passed. We don't need to give foes of important reform ammunition to say, look at this maverick statement. They intend to just totally deviate from federal law. And even though we wouldn't have the word totally, they would still phrase it as that way because look, they're so bold as they put the statement out there. We hate federal law. And that's why I want to go back to the appreciable risk standard, because even saying that we want to lower the standard, it is poking the bear. You'll have people saying, oh my God, California's anti-competitive. It won't let people merge when it's good, and here are all these good mergers. It's going to be impossible to get a merger, even when they're necessary in California, because California has a fixation on lowering the standard. I defer to Cheryl's understanding that appreciable risk is a lower standard. I appreciate the ambiguity that you can't put it in a headline that California is out to lower the standard of proof and make mergers impossible. I'm totally focused on headlines and the marketing of our legislation.
Do we have any additional commissioner
Yeah.
comments? Yes,
I have
Vice Chair?
I have some of the same concerns too. I used to do training for new staff and new assembly members and suggest to them that, don't let the perfect be the enemy of the good. But what I haven't, I don't think I've heard yet is that the substantially standard is the reason that mergers have not been challenged or halted. I also, just as a grammatical, the way it's been proposed here, the way I read substantially is how much competition is going to be reduced, as opposed to the way it reads with appreciable is the probability that there's going to be a reduction in as opposed to how much the competition is going to be reduced. If you say, sorry to be so wonky, create appreciable risk of materially lessening competition. But up at the top it says federal act mergers whose effect may be substantially to lessen competition. The substantially is how much competition is reduced. whereas the comparison appreciably would be materially lessening competition. Those would be the two. And I don't know that, I just don't know what those functionally mean. So anyway, I'm concerned as well.
Now, my understanding is that if the motion, the pending motion were to pass, is that that's what staff would do, right? They would come back to us and give us more analysis of the proposed potential language and what its implication would be. But I do believe that what we're hearing from staff and is that the goal is to have a lower standard of proof for harm for plaintiffs to be able to challenge these mergers, right? So if that is in effect what the goal is, unless that's not the goal, right? And that's a different,
Yeah, that is the goal.
that's the goal,
Well,
right?
I think, everybody at this table except for Sharon is not, Cheryl is not an antitrust expert. I think those words are known in the antitrust world. I'm just looking on the internet and whatnot. Substantial is known to be a higher standard than appreciable. It is. So we're kind of going off track looking at the sources or dictionaries. These are actual terms of art. And I like the word appreciable because it doesn't fit into a newspaper headline saying California is hell-bent on stopping mergers by lowering the standard of scrutiny. I like the ambiguity of appreciable risks. People who know and do this stuff know what it means. And again, the chances of any of these laws passing is almost nil already. And that's why I think we should be focused on how we word these things carefully to not draw headlines.
Are there any additional comments, questions from other commissioners? All right, is there public comment? Is there any? Yes, there is, okay. So we have in-person commentator? Now there's one, great, okay, go ahead.
Great, thank you, Madam Chair, Commissioners. So, speaking on behalf of the Motion Picture Association, we're opposed to this change. There's lots of solid merger enforcement today. The Kroger-Albertsons merger was blocked. The Simon Schuster Random House book merger was blocked. There's plenty of examples of mergers that are blocked, and also mergers that are just abandoned after they get considerable scrutiny. Changing the law here to be different from the federal standard that seems to work pretty well, I think it's just going to create uncertainty, and then other states won't sit still. Maybe they'll do their own thing. Certainly some states aren't going to copy us. I think that creates a lot of additional cost in the system. I think here too, this is one place where we really have to study, do we need this? Do we need to change this standard? Do we need a problem? So, the commission put out this concentration report. The U.S. Chamber of Commerce hired an economist who came to contrary conclusions. This is a place where, if we're going to have an impact on the amount of deals that get done, we need to have a good sense of whether or not change like this needs to occur, so that we don't create a lot of collateral harm. And then finally, this should be obvious and it's a practical point, but we have a lot of companies in the state that conduct this activity. We have a very strong tech sector. It's not big, but it's very strong. Same thing with life sciences. We're the home of the world's motion picture and television business. These companies produce massive benefits for our balance of trade with other countries. One of the few businesses that does this. Changing the law to make it harder on all these people and maybe causing work to go to some other states. We need to be in this place more than others. I think we need to be very, very thoughtful. So the bottom line is, we would oppose changing this standard. So thank you.
Thank you. And our virtual commentator?
We have Ben Gollenbeck.
I'll be brief. This is Ben Gollenbeck from the California Chamber of Commerce. Once again, I will associate my comments with Mr. Robbins' comments, as well as my comments on the previous and related item, as well as with Commissioner King's comments on this. I will use his term of art on this Maverick proposal. And I'll just remind folks again that there's been absolutely zero economic analysis done of what the impact of this would be. And that is incredibly troubling and dangerous for California's economy. Thank you very much. And we obviously oppose the recommendation.
I'm curious, how many challenges have there been in California, if you have that information, on mergers, if you happen to have some kind of data?
Well, do you mean challenges by California alone? California sometimes challenges mergers on its own. And I would say the last 5 years, maybe 3 of them.
3 of them.
But then they often join with the FTC or the DOJ, or they combine with other states. In this last merger, Kroger and Albertsons, California combined with the FTC and other states. Meantime, Washington State on its own went into Washington State Court and got an order enjoining the Kroger-Albertson merger using its state law. In the federal case, the federal court ordered a stay of the merger pending an administrative proceeding of the FTC, which had not been scheduled.
Do you believe that having the term lower versus appreciable risk is something that would, as somebody that is an expert and knows this community, would be something that would kill the work that we're doing and moving forward in this particular issue?
Oh, that's, I didn't touch that one.
Okay.
More of a political question.
Not to put you on the spot or anything, but, okay, fair enough. Do we have additional? Okay, there's, we'll go ahead and take our in-person first, and then we'll go to our virtual commentator.
Good afternoon, Commissioners. Ben O'Brien again with California Life Sciences. I just had a point of clarification. So earlier we were discussing the abuse of dominance standard, and I believe that that was contained within the single firm conduct portion of the discussion, or like that would be applied to the single firm conduct alone. So I just kind of wanted to clarify, is the idea that this appreciable risk standard would be applied just to mergers alone? Or would that standard be applied to other?
That is I think our understanding.
Okay, understood. And then I would also voice our opposition to the use of that standard. And again, saying our industry has some particular nuances that mergers and acquisitions are very important for, and these additional layers could slow us down, slowing down patient access.
Thank you.
Robert Harrell.
Hi, thank you, Madam Chair, members of the Commission. Robert Harrell, Executive Director of the Consumer Federation of California. We support the motion as we understand it that's before the Commission on this issue. I would just note that listen to the rhetoric, maverick, radical, getting a little bit annoyed at this repeatedly being trotted out in this context, because let's not lose sight of what we're really talking about. We're really talking about better understanding the impact on consumers, among others, of a merger. The data is pretty clear that it's a tiny number of these mergers that get scrutiny. We can debate whether that's going to go up or down in the next 4 years or at the federal, state level, but we think it's completely appropriate for the staff to thoroughly explore this in a thoughtful way. Appreciate the conversation of the commissioners. Thank you.
Thank you. Commissioner King.
Yeah, I think that's a great comment. And just to express my view on everything we've discussed today, nothing we're doing is maverick, in my opinion. we're giving staff permission to experiment. California is the center of innovation for this nation. And we all know antitrust isn't working on some level. I disagree with the people who say that antitrust is perfect and the status quo is perfect. I think the evidence shows that's not true, but I'm not out to be a maverick. I'm out to explore new avenues. And the reasons I've supported all of these motions and all of these recommendations is because we're just telling staff, give us ideas. Those ideas can be wholly rejected by us, wholly rejected by legislature. But if we vote no on this measure or any of the former earlier measures, we're basically saying we don't want to know. We don't want you to explore. We are happy with the status quo. And I don't believe that. So we might wind up at the end with a lot of things that are status quo. I would see it that way, but I want to let staff show us the world.
I agree with you. I think it's really important for us to be able to make as informed decisions as possible. And that is why we have staff to be able to do this kind of a deep dive. So thank you. And we have another comment.
I'm sorry to come up again. That comment just sparked something in my mind. I think we agree that we'd like to have that exploration, but I think as Ben continues to say, we'd also like to see an exploration of the economic impacts that some of these proposals would have on particular sectors. So thank you.
Additional virtual comments? Oh, okay, go ahead. One in person.
Two comments. One is I like Commissioner King's earlier reference to the phrase that often gets attributed to Voltaire, which is "Don't let the perfect be the enemy of the good."
Oh, that was Vice Chair.
Commissioner Simpson,
Yeah.
sorry. I'm not opposed to exploration, but the exploration has to be appropriate and balanced. So here, I don't think the staff has access to economic resources. We have a staff at the ULC too. We don't have economists on staff. It's a pretty significant exercise to place on the staff you have. I frankly don't think they've got the resources to do it. And you need it to be balanced. We have the construction of the working groups, in my opinion, was not balanced. It was heavy on the plaintiff lawyer, academic side. I think there was less than a handful of people on the defense and the company side. And so you got the recommendations you did because I don't think it was balanced. So if you want to do the work, I personally think that's great. You got to make sure you've got the resources and you look at it fully and not just in some imbalanced fashion. So sadly, I've noticed that it's my opinion, that's happened in this process. And you look through all the people on those working groups and who appeared most often, I feel like very much off to the side because I'm not a plaintiff's lawyer, but just think of that because I think there's much less opposition to something if it's going to be done in a full and balanced way and you get some real economists to apply themselves to it, et cetera, et cetera. It's a significant exercise though. And I think you're hearing that from the Cal Chamber a lot because they're focused on that. And, in fairness, these are really big controversial changes at the end of the day. And so we want to make sure that we don't have a lot of unintended collateral consequences that are harmful to the state. So thank you.
Thank you. Commissioner Carrillo?
Yeah, I just wanted to give staff an opportunity to respond to that. Does staff feel like it's the case that there was any imbalance in the makeup of the perspectives in the working group? If that's so, then I would be a little bit concerned because there were a couple of places in the memo that presented things as there was a consensus among the working group or there's a consensus among thinkers in this area. And that, we might be getting an inaccurate impression if that consensus is limited to, one corner of the thinking universe. But if it really does incorporate, opposing points of view, then that's a different matter.
So, as you know, I joined the commission after the expert working groups were formed, but in looking at the history and talking to the former executive director, I think there was a lot of thought and effort into making it as balanced as we could. So I understand that that's a perspective, but I think from staff's perspective, and I'll ask Cheryl too, because she knows the community better than I do, that there really was an effort to, so if you want to talk about academics, that we had academics on both sides or in the middle or whatever the range of opinions were, so it wasn't just focused biased one way or the other. And then another thing that we asked the working groups to do is circulate their drafts with the other working groups. So if one particular working group maybe was a little off to one side or the other, that they would get more balanced perspective from other working groups. So I appreciate the comment, but from a staff perspective, we don't believe that there was imbalance. Didn't know if you have anything to add to that, Cheryl.
Not much. I think an effort was made to extend equal amounts of invitations to join the working groups from those on a plaintiff perspective with those with a defense perspective. Academics were chosen from a full range of ideologies. And we had economists that spanned the range of conservative to liberal. And I think very important, and certainly you could look at each individual working group and say one might slant one way than the other, but we saw it in both ways. There were certain groups that basically had mostly defense-oriented academics and professionals, when you could say other groups had some that had a preponderance of academics and participants from a plaintiff's perspective. But then they all shared their drafts and made their presentations, and I think the presentations were made with a balance of people, so, yeah.
Could I ask if, because it sounds like, you know, we have to take a vote on this last one, but it sounds like it's gonna pass. And so I think what we're gonna wind up with is everything that was in this memo is gonna wind up going back to staff for further work and development. And at some point, we're gonna be looking at a memo that has some concrete proposals in it. And it just something to consider in the way you build that memo. It might be beneficial to, for each of the bullet item proposals, to style it as majority, minority, or pro-con, rather than this is what we think you should do with no context. You know, like at the high level that we're at now, we're evaluating things at a macro conceptual level. And I think it's okay to not, you know, to not delve into competing points of view in any detail at this point. But when we look at specific proposals, you know, I actually would like to know what the counter argument is so that we as a commission could evaluate that.
Yes, absolutely. And in the previous memo, 2446, we did try to provide as much balance.
Yeah.
For this one, we were trying to
That's
just
the
get
kind of thing I'm
focused
thinking
on
of.
some very high level
Yeah, which is
decisions.
fine.
But yeah, absolutely, we will
Yeah.
include that.
Okay, thank you.
Vice Chair?
Sort of following up on David's comment. It strikes me that this standard of proof issue is sort of a subset, if you will, of merger and acquisition law. That if we've made a decision to try to identify a merger and acquisition law to recommend, I'm just questioning, do we need to vote on this particular issue, or is this something that could be included, dealt with one way or the other, as staff's putting together a mergers and acquisition law?
We don't need it. What we're looking for is direction from the commission. So if that's something you'd like us to consider when we're looking at the mergers and acquisitions, we can certainly handle it that way. As opposed to, you know, the commission saying, staff go out and draft something on a lower standard or appreciable risk. So that way there would be a lot more analysis maybe that would make the commission more comfortable.
Yeah, but in the, in the context, I mean, the mergers and acquisitions law could conceivably end up simply being the Uniform Law Commission thing. I mean, that's conceivable, maybe not, but that would be the pre-merger notification element of what was in the direction to staff. So I'm just wondering if this might be something that would be part of the larger question of what's merger and acquisition law look like.
Yeah, we agree.
All right, well, that was very helpful comment. Thank you so much, Vice Chair. Because given that, I would and I like the fact that what I heard was there would be a deeper legal analysis.
Yeah.
And that's what, as a member of this board, I want to see. So I would withdraw my motion. And I would, rather than it would be a substantive motion, it would be direction to staff to look at this issue of, what is the standard of proof? And then we can have more information. I also want to stress, though, one of the key things I believe in is that, I know that there are legal experts and tons of attorneys that work on these issues, but I want the regular worker, the regular person who is directly being impacted to be able to understand what we're talking about. And sometimes these terms of arts stop that from happening. So I think, and I also recognize the concerns with how it can be spinned and pivoted and made into something it's not. But I think that one of the important roles of this commission is to ensure the law is working. Why? Because if people don't understand the law, if they don't understand how it's supposed to work, there is no due process. Their rights are being infringed. So I want to be cognizant of the language that we use. And hopefully, if you're with this direction, you can break that down for us.
Sure, absolutely. Okay, so we don't
Alright.
need a vote.
So we don't need a vote unless there is an agreement, objection with the direction that I've provided staff. All right, great. Look at us.
So we have one final item
Yes.
in the antitrust memo that does not require a vote. All this is intended to do is flag some issues for future consideration because we have plenty on our plate. But in ACR 95 directed the commission to consider other changes that might be able to promote and ensure the tangible and intangible benefits of free market competition for California. We've listed another of reform suggestions that the commission has received over the past couple of years. At some point, when we get through all the stuff we were discussing today, we recommend that the staff or the commission direct staff to bring this additional information to the commission for consideration at some later time.
Yes, and my understanding is that as you do this work, other issues may come up. So this list may get shorter, may get longer. So I would agree with that guidance to the commissioners. I don't believe we need a vote for that.
No, we do not, just direction. So unless somebody has further direction or disagrees.
Is there a disagreement or objection, additional? Okay, great. So please move forward and we look forward to hearing about those at the appropriate time.
Okay, so do we need we're done. We made it through the whole memo.
Through.
Thank you so much to the commissioners, the senator and the assembly member and all our public participants. And we have public comment.
You do have public comment. And we're happy to hear that. So we have time. And our virtual commentator is?
Ben Gollenbeck.
Okay, great.
Okay, it's been quite a day. Ben Gollenbeck from the California Chamber of Commerce one last time. I'll just say sort of holistically, while the staff's recommendations are certainly comprehensive, we believe they're beyond, they're premature and they're misguided on several fronts, and they don't justify or support the unprecedented revision of California's antitrust laws. And in the strongest possible terms, I cannot emphasize what a stark departure this would be from any sort of current antitrust law or current antitrust law proposal if these were taken together and implemented. This would have a chilling effect on California's economy and lead to a dramatic increase in affordability and costs to Californians. Cal Chamber has expressed before, both in written and oral testimony, that statutory reforms are appropriate when there's a demonstrated need for reform. Likewise, antitrust policy is most likely to benefit competition and consumers when it is based on sound economic analysis. But staff's recommendations do not demonstrate a need for revising California's antitrust law, and there has not been any economic analysis of any impact of these proposals. The key shortcoming we see with staff recommendations is that they do not present evidence demonstrating that California's antitrust laws are failing. That is, the recommendations don't establish that California consumers are suffering from reduced competition, higher prices, or lessened innovation because of holes in the law. And while it's true that staff recommendations rely on submissions made to the commission urging reform, those submissions were authored primarily by plaintiffs' lawyers and consumer protection organizations based on anecdotal evidence and the belief that antitrust law is too, quote unquote, defendant friendly. We urge the commission to not take action unless and until it is clear that something is broken with existing law. Sound public policy demands as such. And for wrapping up, in terms of substance, staff's recommendations are unnecessary and likely to stifle competition. And it's important to note that there are robust federal and state laws that government and private enforcers can use to reach, punish, and deter anti-competitive single firm conduct and anti-competitive mergers. As California citizens, we believe the robust enforcement of the antitrust laws benefits all who live and work in the state. And our state's economy has thrived under California's existing antitrust regime, spurring growth and innovation, all while protecting businesses and consumers from unlawful anti-competitive conduct. And that's on behalf of the Cal Chamber, which has 14,000 plus businesses, from the smallest of small to the largest of large. I will just, a quick departure, just on the last point that was made in terms of the composition of the working groups. I'll note a few things. One, there are definitely cases here where the staff's recommendation directly contradict what the working groups recommended. I will also challenge the fact, and I will say incredibly frustrated to try to sort of do a both sidesism and say that some working groups, were a little more tilted towards defendant and some were a little more tilted towards plaintiffs. And I would strongly urge the commissioners to look at the composition of the working groups and tell me which one was more defendant friendly, because I think you will be hard pressed to see that. And that was honestly shocking to hear. Because it does not match the reality of the extensive work that we have been doing and our engagement over the last year plus on this issue. And I will say certainly very limited, if almost no sort of engagement and sort of asking for sort of feedback from the business community. With that, I thank you for your time and have a good day.
Thank you for your time. Do we have any additional comments?
I have 2 more.
Okay. I would like to note that it is 4:46. We will be ending the meeting at 5 o'clock. There are, I believe, is there another comment here in person? All right, so you have 5 minutes each, and we will be careful to make sure that we don't go over our allotted time.
Travis West.
Hi, good afternoon, everyone. Travis West, Regulatory Policy Specialist with California Nurses Association. Thank you for the opportunity and the time here at the end of the day. We would like to also thank the California Law Review Commission staff for their diligent work in preparing these recommendations. CNA supports the staff recommendations, and while we believe the Commission could take additional steps to protect Californians from anti-competitive practices, the staff recommendations provide an excellent foundation. In addition to supporting the appreciable risk standard and the single firm conduct standard, CNA also urges the Commission to explicitly include harm to workers in labor markets as an antitrust injury and consider such harms in its analysis. It is well documented that anti-competitive conduct by monopsonist employers can lead to unsafe and unfair terms and conditions of employment. Beyond wages, employer concentration can lead to diluted bargaining power, reduce job quality, and increase exploitation of workers. For example, the labor market concentration is associated with reductions in RN staffing, which is associated with more dangerous working conditions for nurses and poorer patient outcomes. Larger employers also have more power to force cost cutting off the backs of workers' health and safety. For example, just-in-time supplies adopted in many of the large health systems resulted in woefully insufficient inventories of respirators and other personal protective equipment, which left workers scrambling to protect themselves during the pandemic. As these examples demonstrate, worker exploitation is often one of the primary results of market consolidation and anti-competitive practices. It's therefore important that the standard adopted by the Commission explicitly include harm to workers in labor markets as a cognizable injury. Moreover, CNA encourages the CLRC to recommend the adoption of a public interest standard that clearly articulates in statute an objective standard that describes what kind of abusive conduct by dominant corporations may be anti-competitive. Current antitrust law fails to consider the social value and necessity of healthcare for individuals, the community, and the economy at large, and it fails to consider the value of healthcare workers who produce it. A public interest standard would help address this shortcoming by clearly considering behavior and factors beyond price, like the negative impact on people in the economy, small businesses, workers, and government participants. A public interest standard would also examine, or should also examine rather, whether monopsonist conduct contributes to racial or income inequality, lack of diversity in a market, unsafe environmental or consumer impacts, and quality of products and services. Thank you so much for your time.
Thank you. And our final?
Natalie Schumann.
Ms. Schumann?
Hi, can you hear me?
Yes, we can. Thank you.
Hi, this is Natalie Schumann again, speaking on behalf of the Writers Guild of America West. Again, appreciate the opportunity to speak more broadly. I wasn't sure if we'd have that chance. So as I alluded to earlier, our members experience the harms of unchecked consolidation firsthand, and we've been speaking out about this issue and advocating for antitrust reform for years. And in June of last year, we spoke to this commission and submitted materials for the record articulating how deregulation and under-enforcement of antitrust has harmed our industry and our members. We're pleased to address the commission again today to express our support for staff's initial recommendations to update the state's antitrust law, and to urge the commission to move forward with submitting these recommendations to the legislature. Significant strengthening of the state antitrust law as captured in the reforms recommended by staff is urgently needed to guard against future harmful mergers in California's already heavily consolidated media and entertainment industry. As we articulated back in June, decades of consolidation have transformed our industry into one dominated by just a handful of companies, including Amazon, Netflix, and Disney, who abuse their position of dominance with workers, consumers, and competitors and threaten to consolidate even further. Weak antitrust law and lax enforcement have enabled waves of harmful mergers between behemoth media companies and vertical integration that cuts out competition from independent producers, leaving just a few dominant firms with tight control over the content that our industry produces, often from the time an idea is conceived until it reaches audiences worldwide. These few dominant firms have used their increased market power and vertical control of content production and distribution to disadvantage their competitors, raise prices for consumers, limit creative innovation, and push down wages and working conditions for creative workers. Writers, our members, have experienced these harms firsthand as their employers leveraged this oligopsony power to worsen compensation models and employment practices that had been industry standards for decades. Pay and working conditions became so dire that in 2023, 11,500 writers went on strike for nearly 5 months to fight for their ability to make a living with their valuable work. Writers won significant gains in that strike, but the landscape of excessive concentration among their employers is only getting worse. In the streaming market, instead of dynamic competition, we see all the major firms raising prices and reducing content spending in parallel, leaving consumers to pay more for less. Despite these already anti-competitive conditions, Wall Street continues to demand even more consolidation. And without government intervention, more harmful mergers and anti-competitive conduct are on the horizon. So with its recommendations to the legislature, the commission has the opportunity to push back against this further consolidation, which looks more and more likely under Trump's administration, and to strengthen competition in this vital industry to California. We urge the commission to recommend the legislative solutions proposed by staff, and which, if they were enacted, would help prevent that further consolidation, which would harm workers in the media industry as well as the vitality of the industry itself. Specifically, state law and enforcement must include consideration of worker impacts in mergers, disregard attempts to offset consolidation's harms, and lower barriers to prove antitrust violations. The state should also pursue increased enforcement against harmful mergers and abuses of dominance, conduct merger retrospectives and market investigations, and empower the state's antitrust enforcers with clear jurisdiction to regulate anti-competitive behavior and mergers. We thank you for the opportunity to comment and for your work on this important subject. Thank you.
Thank you very much.
One more?
We have time. Our third person is?
Mona Masri.
Thank you so much. This will be my last comment. So I'd like to first begin, again, Mona Masri from Economic Security California. I'd like to first begin by recognizing the exceptional work of the staff over the past year who have gathered and coordinated expertise across numerous topics to provide reports, research, and analysis, which has been synthesized into a crisp set of recommendations that we strongly agree with. The staff has shown strong leadership, dedication, and a collaborative and balanced approach in advancing critical antitrust discussions, and the Commission can feel confident that it's moving forward on this well-researched expertise that has formed the foundations for these recommendations. The recommendations discussed today reflect the thoughtful, comprehensive analysis by staff, which is exactly the kind of forward-thinking approach that California needs. As the fifth largest economy in the world, California cannot solely rely on federal antitrust enforcement. While there have been some encouraging steps at the federal level, those remain vulnerable to shifting political priorities and judicial interpretations. What stands out about the recommendations is how they focus on California's unique needs. Rather than simply copying federal standards that have been diluted over the years, they propose California-specific rules and both build on what works at the federal level while addressing areas where federal law falls short. So we do need our own strong framework in California to ensure fair competition while protecting workers and labor markets. Recognizing harms to workers of corporate concentrations is essential, especially with the growing evidence that we've heard today of how market concentration suppresses wages and worsens working conditions. So again, we support the recommendations that have been presented today. I believe that they will have an effect of modernizing our antitrust enforcement by considering factors like quality, innovation, and privacy, issues that are also central to today's economy, especially in the digital markets. So thank you again for your hard work and commitment. We look forward to seeing this process move forward. Thank you very much.
Thank you. No further comments, no public comments from folks here. So at this time then, we will be adjourning. All in favor of adjourning our first January 2025 meeting? If we can all say aye.
Aye.
Aye. Okay, I was gonna say, if you've got an objection, we got 5 minutes, so. Thank you, everyone, so much. I want to thank the staff for all the incredible work. I want to thank the people that are here and the public and our interns, and also the Judicial Council of California for opening their doors and having us here and hosting us, and their staff for the work that you may not see. It takes a whole bunch of folks to make this happen, and all of their work is greatly appreciated by us. So thank you so much, and we will see you, and we're looking forward to hearing from you at our next meeting.
All right.